The Appellate Division First Department is now in session. Good afternoon. Welcome to the Appellate Division First Department's virtual argument session. I'm going to begin by calling the calendar this afternoon. First case is People versus Anthony Castillo. Appellant?
Yes, Victorian Wu for Appellant Anthony Castillo.
5 and 2. And respondent? Amanda Reagan?
Yes, ADA Amanda Reagan.
5 minutes.
Thank you.
Commissioner versus Sanitation is submitted. RF Children is submitted. Powell versus the City of New York.
Good afternoon, Your Honor. Lisa Como for the plaintiff appellant.
And that's 5 and 1.
Thank you.
And for the respondent,
Good afternoon, Your Honor. Alina Drucker for the city respondents.
okay, I'm recused on that case, so for technical reasons, we have to call it last. I apologize for that. It will be called last. People versus Jamal Dilworth.
Yes, Your Honor. Alma Gonzalez, Center for Appellate Litigation for Mr. Dilworth.
5 minutes. And for the
sorry, Your Honor, counsel for Mr. Dilworth. May I reserve 1 minute for rebuttal?
Okay, 4 and 1.
Yes.
And respondent, Beth Fish Cohen.
This is ADA Rebecca Hausner arguing on behalf of the people.
Okay, 5 minutes.
Thank you.
Mikashina versus Tishman Construction is submitted. People versus Centel Smith is submitted. People versus Alion Dionge. For the appellant, Katrina Myers.
Good afternoon, Katrina Myers for Mr. Dionge.
5 and 2. And for the
Thank you.
respondent, Claire Nielsen.
Good afternoon, Claire Nielsen for the people.
5 minutes. Mashenko versus AGA Management. Appellant, Samira Stogie. For the appellant on Mashenko versus AGA Management, is the respondent present?
Yes, Your Honor. Scott Horn for the respondent.
Okay, I'll recall that case, perhaps when we get to it.
He was on the call earlier,
Yes,
if I may.
so I know everyone is supposed
Your Honor, Your Honor, I couldn't unmute my microphone. I'm so sorry. This is Owen Floater.
Don't worry, I understand. Just give me your name again.
Sure, it's Owen Cloder, Sikenzie Ross Ference for appellant.
Okay, that's 5 and 2. And
Yes.
for the respondent, Scott Horn, we have 5 minutes.
Thank you, Your Honor.
Thank you.
Okay. Little Rest versus Zajac. I'm sorry. Emmanuel Zeltzer.
Yeah, no, this is Stuart Blander for the appellant.
And that's 6 and 2. For the respondent,
Good afternoon, Your Honor. Martin Russo on behalf of Little Rest 12.
6 minutes. People versus Ricardo Flores. For the appellant, Angie Louis, or Louis.
Actually, it's Karina Rahal.
Okay. And that's 5 and 2.
Yes.
And for the respondent, Malancha Chanda,
Yes, Your Honor, I'm here.
5 minutes. Berkshire Bank versus Fowler. For the appellant,
Catherine Friedman here for appellant Mark and Melissa Fowler, Your Honor.
okay, 3 and 1. And for the respondent, Ross Hoffer,
Your Honor.
4 minutes. People versus Leonard Woodard. For the appellant, defendant,
Jody Ratner for appellant Mr. Woodard.
6 and 2. And for the respondent,
Philip Tisney for the respondent.
5 minutes. Hoffman versus Babad is submitted. Satiros versus 7-Up Construction. For today, we have AJ Greenwich Contracting and 7-Up. So for the appellant, AJ?
Marijo Dukovic for appellant, respondent AJ Greenwich.
And I gave 5 minutes, but you are, so I'll give you 4 and 1. Do you want
I think
rebuttal?
that was, yes, that was what the email indicated. Thank you.
4 and 1, exactly. And for the respondent?
Stephen Harfin is for the respondent, cross appellant.
And your cross appellant, I gave you 4, but I'll give you 4. Do you want rebuttal?
Sure, Judge.
You don't have to.
I'll take a minute.
Okay, I'll give you 4 and 1. All right. I'd given you 3 before. Okay. Foran versus Computershare, Inc. Robert Heim for the appellant.
Yes, good afternoon, Your Honor. Robert Heim.
5 and 2. For the respondent, James Henry Forte.
Good afternoon, Your Honor. This is John August. I'm actually the New York attorney, and I'm going to ask that Mr. Fort, who is admitted pro hoc vice, be permitted to honor respectfully.
I'll grant the request. So Mr. Fort is 5 minutes.
Thank you, Your Honor.
Rosenberg Feldman versus 95 Madison is submitted. Jen versus Ratnathakam is submitted. People versus Brand, People of New York versus Brand. For the appellant,
Good afternoon, Your Honor. Adam Meyer for Mark Simpson.
5 and 2. And for the respondent, Lucy Nicholas,
Good afternoon, ADA Lucy Nicholas.
5 minutes. When I call the case, just give me 1 minute before you begin, or just until I let you know to begin. So the first case for argument is People versus Anthony Castillo. Okay, you may begin.
Good afternoon, Your Honors. Victorian Wu, Office of the Appellate Defender, on behalf of Anthony Castillo. The record in this case includes an extensive and compelling array of mitigation that warrants a lower sentence. First, the record shows that this was...
So counsel, if I may, this is Judge Gonzalez. Of course, the panel has read the papers and looked at the record in this case, and we're aware that the defendant has an extensive history of mental illness, but wasn't this taken into account? Haven't these different mitigations been considered? And in light of the fact that there was a rape in the first degree and a knife was displayed in the presence of a child, wasn't one thing weighed as against the other?
Well, this court has the power to come to its own determination as to the appropriate sentence that should be imposed in this case. And I think that if you look at the record in its entirety and place the incident in the context of Mr. Castillo's life, it is clear that the combination of a 15-year prison term and 20-year PRS term, which adds up to 35 years of time in custody and state supervision.
This is true, counsel, but the plea resulted in a negotiated sentence of 15 years and 20 years PRS, as opposed to the maximum aggregate of 25 to life. So didn't he get the benefit of the bargain here?
You know, even accepting that the plea was favorable and it was a negotiated plea, this court has reduced sentences in cases similar like this one. And I would draw this court's attention in particular to the case People versus Reyes, which I cite extensively in both my opening and reply brief, which has many similarities, like the case here.
If I might, counsel, this does not have a waiver. There is no waiver here. So you're right. It's a negotiated sentence, but we are completely within our authority to reduce it. But the defendant here was sentenced right in the middle, 15 to 25. I think he got right just about in the middle of the sentence, 10 years. And his post-release here is, I understand it's a maximum of 20 years. That wasn't in the center, but given the defendant's history, the incarceration is one thing, but the fact that and it's a very sad case, I will give you that he has mental illness. He suffers from mental illness. And it's a difficult thing to treat. He's been in and out of the hospital, and on occasions when he is out, who can control the taking of medication? He suffers from the illness, and that was the circumstances that caused him to commit this crime. Don't the 20 years, provide the kind of supervision that someone who will be out of jail and maybe not, supervised with regard to medication, doesn't it provide that supervision that he may need?
Your Honor, no, if it does, then I think that would actually justify reducing the prison term further down. I mean, I think the record shows that Mr. Castillo, particularly in light of this incident, has come to a very strong understanding that he needs to take his medication. I think he understands that when he does not take his medication, he can do, something terrible can happen. So the record shows that he has insight and judgment into his mental health. And as I mentioned, People versus Reyes is a very similar case where the individual at issue, was diagnosed with schizophrenia, stopped taking his medication, pled guilty to attempted murder, which is a very serious charge. But this court reduced the sentence from 11 to 8 years, noting in part that the individual had acquired insight into his mental health condition. So I think, given the other mitigating circumstances in this case, including the fact that Mr. Castillo has no prior felony record, this was an isolated incident in his life.
Counsel, what happened to the charges at the correctional facility that the defendant incurred while awaiting sentence?
Well, I am not
Those
aware
included
that
an assault, right?
I am not aware that they actually resulted in any conviction, Your Honor, and the record does not show that there were any actual convictions. So
you have a little less than a minute left.
Yes, Your Honor. So I would ask that you, again, put the incident in the context of Mr. Castillo's life history, the fact that he has accepted responsibility, has had a history, a traumatic childhood during which he was abused, and the fact that he has come to an understanding of his mental health illness. And so I would ask that in light of all these circumstances, that you reduce his sentence in the interest of justice. Thank you.
Thank you. Ms. Regan?
May it please the court, Amanda Regan on behalf of the people. Defendant's fairly negotiated sentence of 15 years in prison for forcibly raping his cousin's wife at knife point was fair and appropriate and should not be disturbed on appeal by this court.
So the defendant was sentenced right in the middle on the incarceratory period. Wouldn't a sentence similar to that on the PRS be more appropriate than the 20 years? Would it be more appropriate? In light of what counsel has said about his coming to terms and the realization of needing to take care of his mental illness?
Your Honor, I think that it's the people's position that the 20 years is post-release supervision is entirely appropriate for someone in this defendant's situation. As Your Honor alluded to, having a longer term of post-release supervision would provide him with the supervision that is possibly needed by somebody like himself, who's been in and out of mental health treatment and who has admitted that he goes on and off of his medication. And unfortunately, what happened to the victim in this case was the result of him not complying with his medication. And so the 20-year post-release supervision term, I think, is good for a defendant in this situation because it will provide him with the structure and the supervision necessary to make sure he is getting the mental health treatment.
Counsel, you don't consider the fact that he's been diagnosed as schizophrenic and bipolar, that he's had 3 psychiatric hospitalizations, and that this was, in the eyes of the defendant, a psychotic episode. You don't think that all of these factors constitute extraordinary circumstances?
I think that certainly they are mitigating factors, but they were all well before the sentencing judge. The sentencing judge was also the plea judge, Judge Whitner, and she ordered the 7:30 evaluation to be conducted before defendant entered his plea, and she reviewed those reports, you know, at the time of the plea, at the time that the sentence was imposed. And so her conclusion that the 15-year agreement between the parties was an appropriate sentence for the defendant was made in full understanding of his mental health history, of his all of the mitigating factors that defendant now points to on appeal. And so defendant doesn't point to anything above and beyond what was before the sentencing court, and the sentencing court felt that 15 years was appropriate. And it's our position that 15 years in prison and 20 years post-release supervision was entirely appropriate for a knife point rape, especially given the fact that defendant was facing, if convicted after trial of the top count.
1 minute remaining.
Thank you, Your Honor. If convicted after trial, defendant was facing, you know, a maximum of 25 years to life. And just going back to Justice Gonzalez's question about his convictions, the charges at the correctional facility, on his pre-sentence report, I don't have the page in front of me, I apologize. It says that on December 6, 2015, defendant was found guilty of assault. But even putting that aside, the sentence here was entirely fair and appropriate given the circumstances of the crime, the facts of the crime, and given the fact that Judge Whitner had all of this information before her when she reached her sentencing decision. And if Your Honors have no other questions, we ask that you affirm defendant's sentence.
Any further questions from the bench? Thank you. Counsel, rebuttal? You have to unmute. You didn't unmute. Unmute.
Yes, sorry, Your Honor. So just briefly, again, I think in light of the extensive mitigation in this case, I think that a combined 35 years of time in state custody and supervision is just overly long for someone like Mr. Castillo, who has no prior record, who this incident is clearly an isolated, aberrational occurrence in his life history, and he has an understanding of his mental health condition. I think when you look at the record as a whole, I think it's clear that the sentence is excessive and should be reduced in the interest of justice. Thank you so much.
Thank you. Thank you both. I just want to note that I neglected to give my usual introductory instructions, and on the theory that it is never too late. Although you are all seasoned attorneys, please let me just remind you that we have your record, we have the briefs, and we are fully familiar with the facts of your case, so go directly to the points that you wish to make, and please don't speak over the justices, especially during virtual arguments, so that you can hear the questions, and keep your mics muted. I'll try to remember to tell you to unmute your mics. Okay, we are on to, and that was no reflection on the first case that was argued. I simply forgot. Okay, so we are on to People versus Jamal Dilworth.
Yes, good afternoon, Your Honor, and may
Just
please
give me a minute, please.
Okay.
Skip.
Okay, thank you.
Okay, thank you, Your Honor. And may it please the court, Alma Gonzalez for appellant Jamal Dilworth. I'd like to address the stop issue first. First to stress that although the facts here are very similar to those in People v. Pena, which was argued before the Court of Appeals earlier this month, the issues aren't actually the same. One issue in Pena was as to what VTL section applies, and the issue here is specifically whether VTL section 375 sub 40B provided probable cause for the stop, which we submitted did not.
Isn't the ultimate issue about the ambiguity of this statute? Isn't that really the ultimate issue here? Correct. Whether the statute is ambiguous or not? Isn't that what the Court of Appeals was considering before it now?
Well, there is a threshold question in the Court of Appeals case because there was a lot of dispute about, well, is 375-40 sub B the only statute that applies? And that question isn't before the court. It's never been contested that here it is just that that section of the VTL that applies. And so what we're really focusing on is whether that statute is clear. And we submit that it is. And I think it's helpful to again read the statute, which I'm sure your honors know, says every motor vehicle shall be equipped with at least 2 stop lamps, 1 on each side. And here Mr. Dilworth had that. Both the left and the right stop lamp were lit and were visible.
So counsel, I was part of the bench in Peña, and as I'm sure you know, what your adversary is arguing is that VTL 375 be read together with 79.21 E6, that they're complementary statutes because the car was manufactured after a date certain, at which time you had to have that center brake light in order to pass inspection. What difference does that make here?
So I would first like to clarify that this is an issue that wasn't raised below. This is the first time that it is being raised. And I think to even get there, we would have to assume that 375 on its own is unambiguous. But so assuming that, I think if you read those 2 statutes together, all that the other statute requires is that the lights be in good working condition, which the lights that were required here by 375, if we do read them together, were. And I think that we can go a step further, and if we are going to reach outside of 375, look at 376-A, which talks about defective equipment and what police officers can and cannot stop drivers for. And if we read 376-A, it does refer specifically to 375 and 376 and talks about what stopping people for what is required equipment. And again, referencing back to 375, 2 stop lamps here was all that was required. And
if you're finished with your answer to Judge Gonzalez's question, I'd like you to turn your attention to the question of the validity of the appeals waiver.
Oh, sure, Your Honor.
So you off if you were not finished with your other answer.
No, I was done, Your Honor. I can switch to the waiver. So the appeal waiver here was unenforceable, and the main problem was that the court was the one who imposed and mandated this appeal waiver and not the prosecution. And when the court did that, it essentially insulated itself from review, which has been found to be problematic, at least in the Second Department in People v. Sutton. And I think that the circumstances surrounding the imposition of that waiver here are troubling for many reasons. And one of them is that there was a lot of back and forth before the appeal waiver was taken about, well, there is this other issue remaining, and it's very important, not just for counseling Mr. Dilworth, but for counseling many other defendants who were facing the same accusations, or at least the same reasons for a stop. And even then, the court didn't at least limit the waiver to exclude the suppression issue, which only added to the inference that, you know, the court was really insulating review of that particular issue.
Is the court's imposition of the waiver beyond the role of the court, or is it within the court's purview?
It's within the court's purview, at least as far as supervising the fairness of a plea and plea negotiations. And in this court, in this case, it was the court negotiating the plea. And so there is a troubling sort of conflict when it comes to these negotiations. And I think that's why the court, at least in Sutton, said that when it is the court negotiating, the court has to dispel these implications that it could be becoming partial in these circumstances. So I don't think that.
So you're saying this violates the court's role as a neutral arbiter in this circumstance?
Correct, Your Honor, at least under these circumstances, yes.
Anyone raise that? Did defendant's counsel raise that below at all?
I don't believe that counsel at least raised the issue about this being a court negotiated plea waiver. He did that on more than one occasion, I believe, and this was before, again, Mr. Dilworth even signed the waiver.
What do you mean? You're saying he objected to the waiver because it was imposed by the court?
Counsel didn't ultimately object per se, but he did at least raise the concern beforehand.
Can you tell me what you mean by that? How do you mean that he raised a concern?
Sure. So I think if we go to, let me just find quickly the page here.
Yeah, just is there something general what was generally what counsel said that would give anyone an idea that this was going to be an issue?
Sure. So at one point, counsel says, are you sure? Are you still, mandating the appeal waiver here because this is a court negotiated plea, not a plea with the prosecution?
What page is that?
Trying to.
Yeah. Well, you can give us. If you can't find it, address it now. You can give it to us on rebuttal. Okay. Let me just ask you, it seems to me that the issues in Pena are still relevant to this case here. Are you saying that they're not relevant? Because it still addresses a statute and the ambiguity of a statute. Very similar.
Correct. If the Court of Appeals in Pena does solely focus on 375, then I think it's directly on point in this case. I won't contest that, but I think if the Court of Appeals does consider these other outside statutes that aren't at issue here, then it wouldn't be directly at point because the issues are really different, and it's because of that threshold issue in Pena as to which statutes we're looking at.
Okay. Thank you. You can answer the specific question as to the page on rebuttal, okay?
Okay, thank you, Your Honor.
Thank you. The people?
Yes, good afternoon, Your Honor. It's Rebecca Hausner on behalf of the people. Before this court even reaches the issue of the reasonableness of the VTL statutes at issue and also the reasonableness of the stop under the VTL, I think it's important to acknowledge that the court ruled that the stop was lawful based on safety concerns. So even setting aside the issues raised in Pena and the issue that the VTL presents, I do think that the safety issues sort of go hand in hand with the equipment violation in this case, and that's exactly why the court ruled as it did. It took judicial notice of the fact that a center brake light is now required of cars on the road, and that's precisely because of safety concerns.
But if Pena found that the statute was unambiguous, then that wouldn't be substantiated, would it? Because then I think that then we would have to find that there is no reasonable suspicion where the statute is unambiguous.
I do still think that the safety issue is just a separate concern outside the context of the VTL, of the equipment violation issue. Again, because the court was taking judicial notice of the fact that center brake light is required, first of all, and second of all, does make for safer driving on the road. And that's sort of an obvious conclusion because a defective brake light makes it harder for other cars to see that that this car was slowing down. But again, even if this court does want to reach
Counsel, are you saying that Dilworth and Pena are two different cases?
They are much different cases in the sense that this court, the hearing court consciously ruled on the safety issue as opposed to the statutory issue. So again, I think the VTL issue is a little bit beside the point in terms of the validity of the stop here. But if this court does want to address the VTL issue, then we certainly need guidance from the Court of Appeals in the Pena case. Because the VTL specifically says in section 300 that the entire title controls the use of motor vehicles and their accessories on public highways. So it is proper to look outside the plain language of 375, although I do think that there are ambiguities just reading that statute alone. But there certainly is case law in New York in the Second Circuit and also at the trial court level saying that when you read the VTL as a whole, these ambiguities are created. So it certainly would be appropriate to wait for the Court of Appeals to address this issue in Pena, which was argued just a few weeks ago. But I would like to emphasize that the hearing court's ruling was a separate issue than the VTL and statutory arguments that appellant raises now.
So I have two questions, one about the waiver and one about the statements. With regard to the waiver, do you have any case law that supports a court imposing a waiver requirement for a defendant to accept a plea offer where the prosecution doesn't initiate or does not make that waiver a part of the negotiation?
I don't have any specific case law that points to that issue. However, I do think it's important to look at the record, and the defense attorney presented to the court that his client wished to avail himself of the court's plea offer. So this idea that the court was sort of became some sort of non-neutral arbiter, I don't think is fair to the record. The defense counsel, affirmatively stated that his client wished to take advantage of this very generous plea offer, which guaranteed his client the minimum prison term. And he asked the court whether or not the court was still requiring the defendant to sign the waiver. That was the language, and it's on page 3 of the transcript. And the court responded that it was. But I think this idea that somehow converted the court into a non-neutral arbiter is just simply not true to the record. And that's not enough to invalidate the waiver on appeal, especially because there was a thorough written waiver that complemented the oral colloquy.
It's not so much, I wasn't really asking whether it was a valid waiver or not. I'm really limiting my question to the role of the court and whether the court has the authority to impose a waiver in these circumstances. So moving on to the next thing I had with regard to the statement and suppression, although I understand if there's a waiver, a valid waiver, then we don't reach this issue. But if we find that there isn't a valid waiver, I mean, if the court didn't have that authority, then we have to get to that other issue. The statement here that the police say that they made the statement based on reasonable suspicion. And they say that they had reasonable suspicion because there was a smell of marijuana and they saw the smoke coming out of the car. But for the same reason, they say they smelled marijuana, etc., and there was probable cause to arrest the defendant. So I'm confused as to how it can be both. If you smell marijuana and you see the marijuana smoke billowing out of the window, at least at the time of this, when marijuana was illegal, that's probable cause to arrest. Therefore, there's a requirement to give Miranda warnings. I don't see how this statement, the eliciting of the statement, makes the statement non-suppressible under those circumstances.
Yes, Your Honor. I think that the situation was rapidly evolving. So in terms of the terminology that was used, when the officer was first approaching the vehicle and saw the smoke and smelled the odor, that didn't, I don't think it necessarily converted over to probable cause until the interaction with the defendant in which he admitted that he had been smoking marijuana. I think that statement...
But let me just say, also, I missed one thing, because he said he smelled the smoke, he saw the smell the marijuana, saw the smoke, and saw the bag of marijuana. All of that he said, and then he asked the question. So I don't understand. I mean, you know, can't have it both ways. So, you know, that's not a basis. Anyway, I'm just, do you have any response?
I certainly understand the concern. I would just underscore that the timeline was sort of rapidly developing. So I think to sort of pinpoint the exact moment that it converted to probable cause from a founded suspicion is challenging. And in terms of, you know,
I thought it was easy in this case. just with regard to that limited fact. The other issues are a little bit more challenging. Anybody have any other questions?
I have one small question on the waiver issue. Is there any dispute that the people did not raise the issue of a waiver at all and it only came from the judge?
On this record, I don't believe there is a dispute. It was raised by the judge, but it is the people's position that it is fair for the judge to condition. Yes, thank you.
Anybody else? Okay, so thank you, counsel. Counsel?
Yes, Your Honor. Respondent is correct that the page that was asked for is page 3, and reading that now, defense counsel says, Judge, Mr. Dilworth is in a position where he is going to go forward, but this is not an offer from the prosecutor. It's a plea with the court. You are still requiring the waiver. So that's the point at which counsel did raise this as a concern. And to go to respondent's argument about the court's finding this to be a safety stop, more or less, 2 points with respect to that, Your Honor. First, there was no evidence in the record to support a finding that the officer stopped Mr. Dilworth because of safety reasons. And on the contrary, he was very clear that he stopped Mr. Dilworth because he believed the defective center brake light was off, and he believed that that was a summonable offense. So that the reason for the stop here was clear, and it was not for safety reasons. And even if there were safety reasons, the standard with respect to vehicle stops is probable cause to believe that there was a VTL violation, and a concern is not a VTL violation. So the suppression court here made an error of both law and fact with respect to that. And going to the point about section 375, and I believe respondent's position is that this issue is unpreserved, and that this is somehow only being raised for the first time here on appeal. And I would submit that it's not. I believe in the reply papers, we extensively noted all the moments in which counsel raised this as an issue, even after the suppression hearing. And with that, Your Honor, I think if there are no further questions, then I would rest on the papers.
Okay, thank you. Thank you both.
Thank you, Your Honor.
Next case for argument is People versus Allion Diongue.
Good afternoon. Can you hear me okay?
Just one moment. We hear you. I hear you, but just one moment. Okay. Thank you. You may begin.
Thank you and good afternoon. Katrina Myers from the Office of the Appellate Defender for Allion Diongue. Mr. Diongue's conviction for grand larceny in the 4th degree is against the weight of the evidence. Indeed, the alleged and dubious confession that he made to a store security guard, sales receipts that indicate that a different sales associate conducted the transaction, and video surveillance footage that merely depict Mr. Diongue conducting the benign tasks of a sales associate at work.
So, counsel, yes. Sorry, this, you know, if you ask if it's against the weight of the evidence, if they could have made different findings, the answer is they could have. But then when we look at, you know, we compare the contradicted evidence, isn't there enough to build a circumstantial case here?
I would say that there isn't. The level of inference that's required to find his guilt is far too much. And also, the surveillance footage and the statements are contradictory. So you can't attribute one with being a correct representation of what happened without disregarding the other one. You either have to choose one or the other. So the circumstantial evidence cannot be enough for a finding of guilt.
What do you mean by that? I don't understand what you mean by that.
Yes, I mean that the surveillance footage depicts Mr. DeYonge doing the innocuous tasks of a sales associate. His statement admits to him.
Counsel, the video shows him putting cards into his pocket.
Yes, we don't know what is on those cards or what he's doing with those cards. I believe the detective at trial said it's indeterminable what he's doing without the help of the store security guard sort of navigating the viewer through the footage.
Well, didn't he himself tell the police officer, I had 2 cards, I dropped one card, and miracle upon miracles, I dropped the blank card, I dropped the $2,000 card and gave the blank card, for which no one ever complained. I guess, wasn't the jury entitled to take his own words and with respect to that claim?
Certainly. Our argument is that Mr. DeYonge's own words simply admit to possession, and possession without any additional evidence isn't enough to substantiate a finding of a larceny unless it excludes all inferences of innocence to a moral certitude. And that did not happen here. Or the other way.
There is, right? There's the testimony of the loss prevention officer, right? So that and the person and his evidence together, don't they together at least make out a sufficient case for a jury?
I believe that the jury did not find the statement that Mr. DeYonge allegedly made to the loss prevention specialist to be credible. The loss prevention specialist did not report this alleged confession to the detective when the detective came to arrest Mr. DeYonge. Also, it was said that the loss prevention specialist wrote a detailed report about the confession that was not entered into evidence by the prosecution. And similarly, Mr. DeYonge was acquitted on the other 3 charges on the indictment.
So I wanted to go in that, I wanted to ask you questions about that, counsel. So admittedly, the people here could have submitted additional evidence from additional witnesses. All right. But aren't you basically arguing that because the jury acquitted on 3 out of 4 charges, it necessarily should have acquitted on the 4th? It's a little confusing for me to hear you make that argument.
I'm simply saying that in this circumstance, we're fortunate enough to see how the jury weighed similar pieces of evidence in finding a verdict for the other 3 charges. I believe it's the acquittals simply highlight the weakness of the evidence that the prosecution presented. It's certainly not dispositive.
So you don't think that the jury carefully weighed everything and threw out three charges? And then stuck with the 4th one because that's where they found that the circumstantial evidence plus the testimony that they credited came together to show guilt beyond a reasonable doubt?
I think that that could have been what they found, but I'm asking the court to sit as the 13th juror and we reweigh that evidence, because what was presented by the prosecution is entirely circumstantial. And as I was saying toward the beginning of the argument, one can't simultaneously credit the surveillance footage and credit Mr. DeYonge's statement to the detective as being truthful, because the 2 contradict each other.
And so, you were in the middle of clarifying that. And what you said was the surveillance does not demonstrate, the receipts and the surveillance don't demonstrate that he did anything more than behave as a person would be, a sales associate. But you started to talk about the statement. And you
right, and I'm sorry to interrupt, Judge. But yes, the statement merely admits to possession, and possession alone is not enough to support a finding of larceny unless it excludes all inferences of guilt to a moral certainty. And his statement also isn't demonstrated by the surveillance footage that the prosecution alleged captured the incident. So
we don't know what he has, so we don't know if at the time he had a $2,000 card or anything else.
Correct.
And he goes into the drawer to get some things. He also goes onto his person, into his pocket. Do we know whether they have any kind of cards that they use or different, where they might put, I don't know, what ID cards or whatever they would use to go on computers?
No,
Let me ask you another. That register was the register of another employee?
That was a register that Mr. DeYonge was assigned to, and the, I'm sorry, can you hear me all right?
Yes.
Yes, it was a register that all sales associates had access to.
And so why does another person's name come up? Seth.
We don't know. That was not explained by the prosecution. In each of the transactions that Mr. DeYonge was charged with, there was a different sales associate's name. So the cash registers are, I'm sorry, go ahead, Judge.
On the receipt?
On the receipt, yes. So the cash registers are a series of cash registers on the floor of Saks Fifth Avenue that different employees are allowed to access to conduct a sale. So it wasn't Mr. DeYonge's cash register necessarily, but he would have been required to log in to conduct the sale himself.
And so presumably his name should have been on the receipt and not the other person's?
Presumably his name should have been on the receipt, yes.
Okay, anyway. Are there any other questions? The time is up, but yeah, no? Okay, thank you very much. You have a vote.
Thank you.
Yep. And Ms. Nielsen? Hello, Ms. Nielsen?
Sorry, can you hear me?
Yes.
Hi, good afternoon. Claire Nielsen for the people. Your Honors, the defendant's conviction in this case was sound and the weight of the evidence fully supported the verdict. The critical piece of evidence here was that the defendant confessed to the crime that he was convicted of, and the jury was able to—
But he didn't confess to that crime. He confessed that he had possession. So, but this was the theft. But he doesn't, and I think that I don't know that it's credited. There are a lot of inconsistencies there. I think the one thing he does say is that I possessed, and it's a kind of crazy story he uses, but I possessed that $2,000 card. I gave it to my wife or something like that. He doesn't say I stole it.
Correct, Your Honors. Defendant's argument is based on the mistaken premise that the jury had to accept the whole confession or not at all, which is not the case. So the jury reasonably discredited this, unfathomable story that the defendant confessed to the detective, that he dropped the cards on the ground and that there was another customer involved, because they saw the surveillance video. At no point did the defendant speak to anyone.
Plus he did, let me just interrupt, he did confess to the loss prevention officer, and the loss prevention officer testified to that, correct?
Yes, that's correct.
And the jury's allowed to credit some of that and not credit some of that.
Yes, of course. So the defendant did confess to all of the crimes to the store investigator. Of course, the jury decided to only convict on the one confession to the detective where they had multiple pieces of evidence. It wasn't solely the confession. They had the receipt as well as the surveillance footage to consider. So again, the jury did credit that part of the defendant's confession, that he was the one to issue the card and that he gave it to his wife, and that she had it. So again, there were multiple pieces of evidence here, and additionally—
But we have, I mean, in the weight of the evidence, in viewing the weight of the evidence, there's so much that we don't have here. There's this other person's name on the receipt. We don't have him at the register at the time that the receipt says he should have been at the register. It just sounds like guesswork to come up to follow the line of the circumstantial evidence. to a conclusion of proof beyond a reasonable doubt.
Since there were multiple pieces of evidence here, and the jury did hear testimony from the store investigator about that timing discrepancy, and they credited that testimony, and it was a plausible explanation. I think we all have clocks
But what's
in
the
our house that
plausible
are different.
explanation for not providing what the register looked like at the time of the event? I mean, we don't know if somebody else was at the register at 2:14 because we don't have the register at all.
Of course, Your Honor. So the store investigator testified that there was about a 90-second delay in that footage that he manually spliced and looked at the footage before and after. And the jury was able to credit that testimony and to realize that, you know, we see the defendant in the footage for about 4 minutes doing one transaction, and he leaves the register area empty. So in 90 seconds, it would be virtually impossible for a different store associate to come in, to input his information, to speak to a customer, and to take their credit card information and to complete a transaction. So the jury reasonably credited the store investigator's testimony about the timing discrepancy.
That a minute and a half would not be enough to plug something into a register for somebody else if they were standing. We don't even know if anybody else was standing there waiting. But you're saying it was a credibility issue. They believe that the testimony of the store inspector who came over and said that. Okay.
Yes, thank you, Your Honor. So, of course, we have multiple pieces of evidence here. The defendant conceded that it was him in the surveillance footage, and now that we have the jury crediting the timing discrepancy, that would explain the difference. And there was also a receipt, which indicated that the stolen credit card number was keyed into the cash register manually, and that was at about the same time and at the same register that the defendant was seen in the surveillance footage.
But that's the register that actually the receipt comes up with the name Seth on it, and Seth doesn't testify at trial.
That's correct, Your Honors. But again, we have the testimony from the store investigator that all of the employee identification numbers are listed on a piece of paper for ease of convenience for these store associates to get into their registers, and it's kept in the drawer. And again, on the video, we see the defendant opening the drawer and then plugging something in. Of course, we can't depict exactly what the words are because the screen is whited out, but at least we know that it's not definitive that it is Seth inputting this information. Anyone could have accessed that information. And when we take that combined with the surveillance footage and combined with the confession, the weight of the evidence fully supported this conviction.
Thank you. Counsel,
thank
rebuttal?
Hello, thank you. I would just like to clarify firstly that it was his statement to Detective Thomas that distinguished the crime of conviction from the acquittals. And that statement merely admitted to possession of stolen property. And respondent seems to be somewhat arguing to have your cake and eat it too, that Mr. DeYonge's statement is simultaneously a credible account of what happened or just entirely incredible. And it can't go both ways. And regardless, either way, it's circumstantial evidence that doesn't support the conviction. Yes.
Counsel, I'm not sure why it can't go both ways. I don't understand why the jury couldn't decide that part of what he said was true and part of it was ridiculous. I mean, people often in a single statement say something that's true and something that isn't. And the jury's entitled to make that decision. Explain to me why the jury can't make that decision.
The jury could credit parts of Mr. DeYonge's statement as credible and other parts to be incredible. However, if they were to consider that parts of his statement were incredible, the jury would then have to think about the possibilities as to why Mr. DeYonge was making a statement to the detective, and perhaps it was in an attempt to extricate himself from any sort of crime or any sort of idea that it evinced a consciousness of guilt is similarly unsupportive of a finding of guilt for the charge. And similarly, it's also unsupported by the surveillance footage in question for this count. I would like to also bring up that the store detective did not testify that he saw or didn't see anyone in the surveillance footage before or after Mr. DeYonge was captured at the register. Also, the surveillance footage that was entered for the different counts on the indictment were calibrated to different times. So on one day, the surveillance footage captured the register at 50 seconds before the transaction. For the crime of conviction, the surveillance footage captured 1 minute and 28 seconds after the transaction, I believe. So there is no logic as to why the camera is off or exactly what it's showing. So
So the calibrations, you're saying it wasn't a uniform calibration that was different. It was sometimes different by one HAMEV and sometimes, and was that at the same register?
And that was at the same register, yes, register 479. And there was no indication from the store detective on how the surveillance footage was calibrated, how he did review the evidence, how if there was someone who was at the register before or after Mr. DeYonge was captured, how he determined that Mr. DeYonge was the culpable at the register. We simply don't know that. The prosecution didn't put any evidence to that fact or the absence of that fact into evidence.
Any other questions? Thank you. Thank you both.
Thank you.
Next case for argument is Mashenko versus AGA Management. Just a moment, please. Okay, you may begin.
Good afternoon, Your Honors. Owen Cloder for Kenzie Ross Ferens for the appellants. Can you hear me okay?
Yes.
Thank you. The court should reverse and should grant summary judgment to both appellants on the unpaid salary claims. And
so is it your position that this is ambiguous or unambiguous? It actually, the word says base salary after 50,000.
Correct. Our position is that the appeal focuses on the ambiguity which the court found and the review that they conducted once they found that ambiguity. We don't agree that there was an ambiguity, but the court found that there was an ambiguity. So we proceeded, as the court should have, with the next step, which was to consider the extrinsic course of performance evidence to determine the party's intent and resolve that.
Let me just ask you, do you think those words are ambiguous? Do you think there's anything ambiguous about the sentence itself?
I think based upon the definition of the word sum and installment in that information, I don't think there is an ambiguity because
it's straightforward, right? 50,000 paid in biweekly installments.
Paid in biweekly installments, and it's the sum of 50,000. So that implies that it's over the course of a longer period. It's not 50,000 in biweekly installments.
And it does say base salary following 50,000. The word base salary.
Correct. And in general parlance,
which seems to me implies that base salary is the entire salary.
I agree with you, Your Honors, and that would also be a plain language reading of the contract where most people's salaries are an annual salary. Rarely has anyone asked anyone, what do you make every week? It's what do you make per year if you're talking about a salary in almost every case. And that's borne out then by the documentary evidence. Number one, you have a Skype chat where they're disputing their profit sharing amounts. This is contemporaneous with their resignation, but their own calculations show that they received a $50,000 salary, which they didn't dispute.
It does seem odd, though, that in your opening brief that you didn't argue that it was unambiguous, but I think you explained that you were picking up on the judge's position. That just seemed a little odd. But
that's correct. We were just picking up on the thread of that. We don't agree that there is an ambiguity. But faced with that analysis, we proceeded, and we believe, therefore, that the judge subsequently did not consider the course of performance evidence, which overwhelmingly weighs in favor of our interpretation of the contract. So that left appellant's extrinsic evidence, really, which was only a self-serving affidavit issued 3 or 4 years after the fact, claiming that they had orally protested. That's not entitled to consideration as against documentary evidence because it doesn't cite the specific instances of the oral protest or the substance of those conversations. So you're left with a situation where there's no extrinsic evidence that could possibly resolve the ambiguity in favor of the non-moving party, but extrinsic evidence that fairly conclusively resolves it in favor of the moving party. And therefore, we believe that the Supreme Court on that first count with AGA committed error, and the appellate division should reverse and grant summary judgment to AGA on the unpaid salary claim. And then,
any further questions? Thank you. Did you have?
Well, there's a second claim as well.
Okay.
So
go ahead.
if that claim is against Mr. Cortell individually, and he's not a signatory to this employment agreement contract. Now, Mr. Cortell, when we argued this before the Supreme Court, the focus was directed to the unrelated profit sharing claim, which concerns AGA's profitability, whether certain receipts were documented, items of that nature. But those issues don't apply to the interpretation of the appellee's salary, which is governed solely by the agreements. There was a lot of discussion as to whether Mr. Cortell had produced every invoice and explained every expense. Even if he had, however, that isn't related to the contractual salary provision, which is, again, governed solely by the contract. So there's no privity here, and that's the real reason that Mr. Cortell as an individual should be dismissed individually. And really, our belief is that the error was that the Supreme Court failed to distinguish out the two claims, one of them being the profit-sharing claim individually against Mr. Cortell, the other being the contractual claim to which Mr. Cortell has no privity, and therefore he should have been granted summary judgment. Are there any further questions for me? Thank you.
No. Counsels, Mr. Horn.
Good afternoon, Your Honors. May it please the court, Scott Horn, counsel representing the respondents in this matter. We respectfully submit, Your Honor, that the motion court properly denied summary judgment in this context because the contract in question is subject to varying interpretation. Now,
Counsel, this is Judge Gonzalez. So I'm looking at the plain language of the employment agreement, and you know that in interpreting contracts, we look at word placement and commas and parentheses and every such manner of grammatical device. So in this employment agreement, it does say the sum of $50,000, parentheses, the base salary, close parentheses. The numerical amount is right next to a term that your adversary argues explains and defines what that amount is. Not $50,000 every 2 weeks, but rather $50,000 the base salary. Nowhere in the agreement does it say $50,000 times 26 weeks.
That is correct, Your Honor, but nowhere in the agreement does it say $50,000 as an annual base salary, and I think that's the key here. So as the motion court found, this language is actually subject to 3 different interpretations.
Counsel, isn't a base salary something that is capable of being increased, for example, by bonus payments, commissions, and the like?
Of course, Your Honor. Yes, I agree with that.
So go ahead, I'm sorry.
But we're talking here about a base salary for a contract that's to run for 5 years. It's not a 1-year contract. It doesn't say it's It doesn't say that it's an annual salary. It just says $50,000 payable bi-weekly installments shall be the base salary. So the motion court looked at this very same language that we're looking at and says, well, it's actually subject to 3 different interpretations. One, which is our interpretation.
This is Judge
I'm
Gessler.
sorry. Yes.
The question isn't whether it is in the abstract, whether there are 3 possible interpretations is a matter of grammar. The question is also whether there are 3 possible commercially reasonable interpretations. And I have great difficulty understanding how it could be a commercially reasonable interpretation that these 2 folks who the founders of the company didn't know would be hired in a startup for $1.3 million compensation a year in a contract that is a little fuzzy. And that just doesn't seem to me at all commercially reasonable. It seems to me that $50,000 a year is the only interpretation that's commercially reasonable. I would agree with you that $10,000 a year is also not commercially reasonable. But I just don't see how either of the other two interpretations passes the commercially reasonable test, which I think we have to pay as much attention to as we have to pay to the grammar.
Well,
So
I don't think, I'm sorry.
Under what theory is $1.3 million compensation for two guys off the street in a startup commercially reasonable?
Well, I must say, we're not talking about two guys off the street, Your Honor. I mean, the evidence shows that these are very, very...
No. Two professionals who the founder of the startup didn't previously know.
Deeply experienced IT professionals in an internet startup company, whereas the founder had no prior experience. These gentlemen ran the show. At the end of the day, the contract, to the extent it may be fuzzy, which I agree with you, it is fuzzy.
I don't think that there's anything fuzzy about a base salary of $50,000 a year. That is so straightforward. It's not like one of those things is something possible. It is, what does it say? And it's pretty straight what it says. And I don't see any ambiguity at all there, none.
When you say a $50,000 base salary over the course of 5-year term, Your Honor, it becomes
plus 10% a quarter or 20% a quarter. That's so standard. There's nothing weird or funky about that. What is weird and funky and certainly possible is a 1.3 million plus 10 or 20. That seems to me like one of those things where you ask, isn't that possible? Where really, no, it's not. The words are what they are and they say what they say. It seems tortured, a tortured interpretation to me. And how come you don't think so?
Well, I don't think so because I'm looking at the same language that the lower court was. And the lower court said twice on the record that I'm looking at the same language that you're looking at. And I see 3 different reasonable interpretations. And on the issue of commercial reasonableness, Your Honor, we're talking about 2 gentlemen that immediately impacted the revenue of this company to the tune of millions in less than a year. Well, these are gentlemen with a deep wealth of knowledge.
That's why there's the second part of the compensation.
Well, we don't know that. All we know is what's in the writing. Maybe they expected it was going to be $5 million in the first year. We don't know. And on that point, the defendants
do know. What we do know is that $50,000 is next to the language that says the base salary.
Yes.
There's nothing that says otherwise, or that it's kind of like the contract the agreement speaks for itself.
Well, Your Honor, I would, and as the motion court ultimately found, also would disagree with that concept. If the word annual base salary was in there, I wouldn't be standing here arguing this case today, but it doesn't. And it's not a 1-year contract, it's a 5-year contract.
I'm going to just let you going on about this. Do you have anything to say about the second issue? Otherwise, and if you could wrap it up in 30 seconds.
Yes, Your Honor, of course. As far as the second issue is concerned, it's not a question of privity, it's a question of piercing the corporate veil. And the evidence shows that the defendant was affirmatively looting this company while the defendants were bringing in millions of dollars of revenue. And under the circumstances, pulling hundreds of thousands of dollars out of the company for your own personal gain is quintessential basis for piercing the corporate veil. And that's why it should be denied.
Thank you.
Thank you, Your Honor.
Counsel, for the appellant, you have 2 minutes of rebuttal.
Thank you, Your Honors. Does the court have any questions? I would be happy to answer them.
No, I just want to ask you one thing. Counsel is correct. It wasn't privity. It was piercing that had the individual held there. So why isn't there any possibility of a piercing claim?
Here is the distinction I would make, Your Honor, and that is the piercing claim was addressed as to the profit sharing claim as between Mr. Cortell and the appellees. There, the amount that the company had made in terms of profits would be what was at issue. So if they were entitled to 5% of the profits, well, how much did AGA make and what do the receipts show? Whereas the salary is clearly covered only in the contract, only a part of the contract. And therefore, there's nothing to pierce. There's nothing for Mr. Cortell could have produced every single receipt and document that he ever used at AGA, and it would have no effect on what the contractual entitlement to salary would have been. And he is not a party to that contract. So I would say it is a privity issue. It's not a veil piercing issue because the salary is fixed by the contract, not by how well or unwell or unprofitable AGA is as a corporation.
And so you're saying that one can never be held liable for breach of contract under a piercing theory?
No, because they can be held liable for breach of contract under their profit sharing claim, which is what Judge Maisley determined. But her opinion did not address the salary claim, and the salary claim is exclusive to the contract.
Except the unexplained transfers would have had the effect of undercapitalizing AGA. And so that might be a reason. So there would be questions of fact there if we reach this issue with regard to the possible commingling of funds.
But that would be, Your Honor, a question of damages, not a question as to the amount that they were entitled to in salary under the contract itself. And whether or not Mr. Cortell had looted the company, the question is there an ambiguity as to whether they're entitled to $50,000 annually or?
Well, I said if we reach this issue, you didn't listen to that aspect. If we reach that issue. Thank you.
Thank you.
Thank you, Your Honors.
Thank you all. Thank you both, Mr. Horn. Next case, Little Rest versus Zajic.
Yeah. Hi, may I proceed?
Just one moment. Thank you for asking. Okay.
Thank you. This is Stuart Blander for the appellants. The order in judgment below should be reversed for two reasons. The first reason is that the court erred in holding that the appellants were collaterally estopped by virtue of certain proceedings in the Bankruptcy District and 11th Circuit in Florida from taking the position that one of the appellants, Joseph K., was the beneficial owner of this corporation, Little Rest, which owned a bar in the meatpacking district.
So counsel, I just want to ask you something very simple.
Yes.
So your clients have made similar arguments in Gibraltar before the New York County Supreme Court, in the Bankruptcy Court, the District Court, and the 11th Circuit. And as far as I know, you haven't prevailed to date, right? Same issues, same parties, fair opportunities to present your case, to be heard, and so on. Why are you here again?
Well, if I may, I think your question, Your Honor, goes to the essence of the collateral estoppel argument.
It does.
Right, and the issue.
May I just ask you to answer this while you answer Judge Gonzalez's question? Both the Gibraltar Court and the Florida Court, which was affirmed by the circuit, and by the way, not appealed by you, had to determine who controlled Little Rest. And they had to determine who owned it in order to determine who controlled it. So that is the significance of the collateral estoppel. Isn't that what this court, the lower court here, found in adopting the Florida, the bankruptcy court case and the Gibraltar case? Didn't they have to resolve the same issue about ownership and control?
Well, first of all, the court below did not make any findings itself based upon the Gibraltar case. It relied entirely, if you read the opinion, based upon what the federal courts in Florida did. So it all comes.
And the federal court in Florida relied on the Gibraltar case. So in that sense, the court is relying on both. But okay, I'll go with what you said. That's the case that you didn't appeal, the bankruptcy case.
So, right. We didn't seek cert. That's correct. So the issue, Your Honor, is what exactly did the Gibraltar court find? Number one, And number two, most importantly, because collateral estoppel analysis says it's not enough that an issue be actually decided and it be the same, but it be necessary to the result below. And I think respectfully, when you drill down and try to determine what was necessary to the determinations by the courts in Florida, what was necessary was, as Your Honor indicated, who is in current control of the entity, because that determined which of these two groups had authority to file a petition on behalf of the entity.
And in order to do that, the court had to look at who owned it. And so they necessarily decided that issue. That issue was necessarily litigated.
I think with respect, Your Honor, the issue of who owned it is a little too imprecise. Everybody agrees that Valmore
That seems like a pretty clear, precise issue, who owned it, but go ahead.
Let me tell you why, if I can, Judge.
Of course.
Everybody agrees now, and there was a determination that something called the Valmore Trust was the owner. Fine. And what they rejected was an argument that was advanced by the Seltzer Group that the Valmore Trust did not own it because the asset had been transferred out to some other entity in some other transaction. And that argument was rejected. So everybody agreed that the Valmore Trust was the owner with authority. But the point is, and I think if I can get one thing across, that the bankruptcy petition was filed in March 2011. The issue was in March 2011, who owns and controls. And what all the courts said in Florida was that ownership and control was by the Valmore Trust. The issue before Judge Friedman below was who was the owner, the beneficial, actual, real, whatever you want to call it, owner of this corporation and these assets in 2006 to 2009. It is by no stretch of the imagination necessary for the Court of Appeals, the District Court, or the Bankruptcy Court to have delved into that historical provenance of the assets in order to reach the result it did.
Counsel, didn't the Florida Bankruptcy Court reject your contention that the Valmore Trust was a sham?
Absolutely. And that respectfully is exactly the point, Judge.
And hasn't every single court said that Joseph K. did not fund the Valmore Trust, that it was Mr. Baudry?
When you say there are two courts that said that, Judge. One was Judge Fried in an interim ruling, and everybody agrees, including Judge Fried and including Judge Friedman, that interim ruling, which also concerned standing to sue on behalf of the entity, is not entitled to collateral estoppel effect. So we can put that to one side. The other court that determined it based on evidence, not based on the preclusive effect of some other court, was the Gibraltar Court. I agree. No doubt about it.
That's collateral estoppel, correct, counsel? And that finding by the Gibraltar Court was specifically incorporated under Section 15 of the bankruptcy. When the bankruptcy judge issued its decision, it gave collateral effect to that finding by the Gibraltar Court, even after your argument that it was brought by fraud and everything else that you argued there. So in fact, there was a finding by a court, the Gibraltar Court, exactly the same as what you are asking in this case for this court to hold.
And I will add to that what I've said before is that bankruptcy court, after it did what my colleague just said, which I said before, was appealed, and then you never appeal that. So that stands. That decision stands.
And
so, counsel, you have rebuttal time. I've already gone over the time, so I'm going to go to your colleague, Mr. Russo.
Thank you, Your Honor. May it please the court, Martin Russo for Little Rest 12. Unless the court has any questions about the collateral estoppel issue, I will open up the floor to any questions about self-dealing and waste. And if you don't have those, I'll yield my time in the interest of moving on.
I just have a question about legal ownership versus equitable ownership. What is that? That's that wasn't your argument. That was your adversary's argument.
Your Honor, that's a fiction. I mean, it comes out of something they picked up in the mutual benefits offshore case, which is distinct, and I'll explain why. Justice
I was on mutual benefits, and I will just say that it was a different trust. It was not involving this trust, and there were different issues when we got beyond that. But that was a different trust, not the Valmore Trust.
That's correct, Your Honor. But what happened there was mutual benefits was a hedge fund, and so there were three classes of shares. There was a class of shares that was owned by the managers, which controlled the hedge fund, and then shares were sold to investors, and so they had equitable ownership in the assets. In other words, the investors owned the assets. The manager didn't have any claim on the assets themselves, only on fees he might make in managing the fund. And so the ownership that was determined by Judge Crystal and then extended collateral estoppel and mutual benefits offshore fund was ownership of the management shares, because there was never any contest as to whether or not there were 23 other investors who had an equitable ownership right in the hedge fund's money. And so that's where this whole thing is coming. So they're drawing off that, but in this case, it doesn't apply because it's just Little 12. It was just Little 12 common shares, and the Mr. Zelser and the Zelser group actually invited the bankruptcy court to make the decision on ownership, and necessarily in doing so, Judge Crystal did both the equitable and legal, if there's any real difference there, ownership of the shares by rejecting the claim that Joseph K. had some kind of beneficial interest in the Valmore Trust.
Thank you. Any other questions?
I just want to say, Mr. August, we've been able to see you talking to other people while all of these attorneys are speaking, and it's been really, really, really frustrating because you're laughing and you're gesturing, and we can't concentrate. So please focus. Thank you.
Okay, I haven't. If you would just limit it, I guess I haven't been troubled, but it's a point. Can we go back to the appellant?
Yeah, very, very, very quickly. I think that even though certainly ownership was discussed and ultimate ownership was discussed in Gibraltar, if you look at, for example, on page 1693 of the record, which is the district court opinion, what they say is appellants now claim the bankruptcy court erred in granting comity to the Gibraltar court's implicit finding that the Valmore Trust was valid, and the 11th Circuit picked up the same language. And the essence of what they took out of the Gibraltar decision was the legitimacy of the Valmore Trust and not ultimate ownership, which I think they found not necessary to their determination. With respect to the second argument, even if collateral estoppel applies, the question is whether there was an issue of fact raised on this record with respect to the waste issue and these personal expenses that were paid. And we think that the court erred because the court completely ignored an affidavit, which is on page 1013 of the record, based on personal knowledge, which attempted to justify all of the expenses, number one. And number two, in the context of the kind of business that is being operated, which is an extremely successful business that did about $30 million a year, the kinds of expenses, for the most part, that Judge Friedman found to be waste as a matter of law, paying for apartments, paying for travel, gym membership, clothing, stuff like that, is the kind of things that many, many corporations in America pay for their CEOs because they're legitimate business expenses. And we think that by ignoring the sworn affidavit in the record and saying that, it wasn't detailed enough for whatever reason, the court basically got the summary judgment inquiry backwards. And we think that an issue of fact was raised, even putting aside the collateral estoppel points. I thank you for your time.
Any other questions? Thank you. Thank you both.
Thank you.
Next case is People versus Ricardo Flores. For the appellant,
Good afternoon. Karina Rahal from Office of the Appellate Defender for Mr. Flores.
okay, you may begin.
Thank you. Your Honors, the court in this case didn't believe that it could depart from the board's recommendation where the RAI generally covered the same topics that were included in the mitigation evidence. And that's where the SORA court erred, because the inquiry doesn't end there. And this court has remanded a case to the same SORA court for very similar reasons in People versus Soto, when it said that Justice Farber, as the court quotes, appeared to consider itself unable to engage in the discretionary weighing prescribed by Gelati. Gelati set out the three-part test for determining.
But in this case, counsel, I think the court made clear that it was choosing not to, not that it couldn't. I think was just being sympathetic, but didn't say that it couldn't. But here, in any case, it has to be a factor that hasn't been, not fully taken into consideration of a kind or to a degree that hasn't been adequately taken into consideration and contemplated by SORA. And in this case, we're talking about family support and exceptional behavior, but neither the support nor the behavior is exceptional. It's support. He's got a good family. They're supporting him, but that's not exceptional. Nor is the fact that he had good behavior when he was incarcerated.
So, Your Honor, I think the issue here is that while the court does mention those two things, right, we're talking about the the efforts that he made at rehabilitation and reflection in sex offender treatment programming, along with family support. Those were the two main issues. And while the court did address them, I think what's important here is that the court did specifically say on more than one occasion during the hearing that it didn't have discretion, that it believed that the RAI didn't adequately assess his risk to reoffend, because if it were up to him, these are his words, that he would likely make Mr. Flores a level 1. But the basis for his belief that he should properly be a level 1 was that mitigating evidence that was presented as the downward departure. And I think the reason that I raised Soto and why I think it's important is because that case was remanded in 2019, just some months ago. This SORA hearing happened in 2018. And I think that the court in that case gave the Justice Farber guidance on when he needed to make the Gelati inquiry. I think the word that I think is missing from the analysis for him in this case was the word adequately. Does the RAI generally talk about a topic? That's one question. The other question, though, is does it address it adequately? I think it's clear from Judge Farber's words during the hearing that he didn't think it was adequate, but that he simply didn't believe that he had the discretion to do anything differently. He says that he believes that a level 1 is enough, that he doesn't think public safety will be served by making Mr. Flores a level 2, that he doesn't believe that the RAI is adequate here. And yet he says, but I don't make the law. I can't do it. And I think this court told him in Soto that not only can you do it, but you must engage in the analysis. And here he didn't engage in that analysis in step 1 to determine whether the RAI adequately captured the subject of the mitigation.
Can we, even if we determine that you were correct and that Judge Farber didn't adequately exercise his authority, couldn't we look at the record and decide nonetheless that the result is correct and come out in the same place?
You certainly could, but then I would ask that you engage in that discretionary analysis that Gelati demands. So, I have asked the court on behalf of Mr. Flores to consider making him a level 1. If the court believes that Judge Farber was correct, that he didn't have discretion to really do this. But I believe that the mitigating evidence the analysis wasn't done. even though the court thought he should be a 1 because it would serve the purposes of SORA, and that's really important here. You know, what is the purpose? If it's public safety and he doesn't think that this is serving that aim, then he should at least get to the gelati analysis. And he doesn't really do that. He addresses each of the things sort of individually by saying, I've seen other people do well in programming. I've seen other people with good family support. And I really think he should be a level 1. So I guess the question is, why does he think he should be a level 1? If he thinks that it's because of this mitigating evidence that's been presented, then he has the discretion to do that. But he seems to think here that he doesn't. And I think that this court told him in Soto that he does have the discretion. He needs to go through the analysis. If he does that, and then at the other side, he says, you know, I've gone through the steps, but I just don't think it's not that I don't have the discretion. I do, but I don't think that this evidence is enough. And he doesn't do that.
Thank you. Ms. Chanda?
Yes, Your Honors. You can hear me fine? Okay.
Yes.
Okay, wonderful. Okay. May it please the court, Malancha Chanda for the people. Here, Justice Farber's decision to not downwardly depart was entirely correct.
But what about the argument that counsel's making that the court seemed to feel that it didn't have the authority? What do you have to say about the court's statements to that effect?
Sure. Your Honor, I believe that counsel is mistakenly conflating an expression of personal opinion with the hamstringing of his discretion, and that I kind of liken it as an analog to, like, in the federal sentencing context. We've heard plenty of judges express on the record that they don't particularly like the federal sentencing guidelines, but they're following the law in sentencing. And I think that's what Justice Farber did here. He's expressing his personal opinion, and saying, like, if it were up to him as an initial matter without the constraints of SORA and the guidelines, if he were devising an instrument on his own, he would feel that level 1 is appropriate. But no, he sets forth the SORA test on pages 5 to 6 of the sentencing hearing, and he says these are the tests, and he finds properly that the first 2 prongs, which is to show the mitigating factors by a preponderance of the evidence, were not met. Now, Soto is distinguishable in that not only was Soto, a statutory rape case, and in a statutory rape case, as this court recognized, the discussion doesn't end with the fact that there was no points allotted for force or injury. That's usually what statutory rape is. It's consensual, and age is the usual reason. So in that case, Justice Farber ended the discussion. But here, he recognized that in cases of family support, in cases of participation in treatment, you need extraordinary level of commitment and participation and extraordinary support.
I think the court did indicate that he did read all of the letters and he read all of the writings and everything from the defendant's family and from the defendant himself. And he agreed that the defendant had extensive family support, not extraordinary family support, extensive family support, and that he did extensive self-reflection and work. Not extraordinary, but he's acknowledging that he did, do work. But then he says that he is reluctantly deciding it, but it doesn't indicate that doesn't understand what it was. He said, if I were to decide what level 1 I thought the defendant had to be in this case, I might find that level 1 was an appropriate and adequate level of supervision. I think that's what he's saying. He's looking at SORA and saying, as counsel said, well, if I had to decide it, if I had to put this together, I might say differently. But there's a structure, and in assessing this, I don't feel it's extraordinary.
Precisely, Your Honor, in that he recognizes that he's bound and constrained by what SORA dictates, and that he is considering the factors, and he is considering what they've advanced as mitigating, and he's saying, to the extent, not only are they counted for because they're just not extraordinary enough.
I think most significantly, he says, I granted downward departures, and certainly declined to grant upward departures in other circumstances, but I just don't see it here. I think he says that at page 7 of the hearing. Anyway.
Right, and on page 6 too, he says, I don't think the law would authorize me in this case based on the showing that was made here, meaning that defendant has not made the showing of the extraordinariness that would meet the level of it. And may I just add, just one thing about alternatively, he did, I do feel effectively did weigh the severity of the crime. I believe it's on page 7 or 6. He did effectively do that balancing anyway. I just wanted to say alternatively. Thank you.
Thank you. Okay, we're back to Ms. Rafal.
It's Ray Hall.
Get the name right? I'm sorry, I'm looking. I'm sorry.
That's all right. Your Honors, I just want I understand everything that you're saying, but I do think it's important that that the judge said over and over again that he didn't think he had the discretion. He says that.
Counsel, how do you square that with the judge saying, I've reduced other levels, I've increased other levels, I just don't see that you've made out your case here. I found your argument very, it sounds very persuasive, but if he's in fact done it in other cases, then he understands what his role is at this time.
Right. So it's not that Judge Farber never grants downward departures. It's that in circumstances where the RAI touches on a subject, he fails to inquire any further. And it's that failure to use his discretion that we're saying is problematic. He's saying the RAI talks about it. It already captures that. And what we're saying is that the word adequately is so important here because Gelati says, does it capture it adequately? The judge is saying he should be a level 1. I don't think it's adequate, but I don't have discretion. I mean, that is what he's telling us in the case.
I don't think he's saying that at all. I think he is exactly what he's saying is if it was my world and I was king, this is how I do it. But I have this structure that I have to pay attention to, and you have to meet a certain burden and you haven't done it. That seems to me like what he said. And even when he talks about burdens, he talks about the fact that he understands that he has the ability to do this back and forth. I don't see him saying, I have no discretion at all.
And after he discusses that aspect of what in his perfect world, as my colleague said, he would do, then he goes on to this client and says that the defendants, I'm paraphrasing, that he added that the nature of defendant's crime against the young victim would give it, now I'm quoting, pause to grant the downward departure under these circumstances. And then he goes on to saying, I've done the up, I've done the down, I don't see it here. I mean, it's quite clear when you read the entire record, Judge Farber is not saying, gee, I don't know how I'm supposed to handle these cases, whether I'm supposed to be having this discussion or whether I have the power or authority to grant a downward departure. That's not what he's saying. He's saying it's not, I see it, very nice, but not adequate.
So I take issue with your reading of it only in that what he's saying is if I had discretion, it might give me pause. If I could do this, I might give him a level 1, but he keeps telling us that if I were able to do this, I might go this way and I might go that way, but I'm not able to. He's not doing the weighing that Gelati demands. So I don't agree that he has done that analysis. I think what he's saying is if I were allowed to do the analysis, I might come out this way and I might come out that way, and I'd probably give him a level 1, but I just can't do it.
Thank you.
Thank you.
Thank you. Thank you both.
Thank you.
Berkshire Bank versus Fowler. Ms. Friedman?
Yes, are you ready, Your Honor?
Yes.
Okay, may it please the court, Catherine Friedman, representing defendants, appellants Melissa and Mark Fowler on this appeal. Your Honors, this appeal is not about notice. This appeal is not about standing. This appeal is about the burden that plaintiff had to meet in moving for summary judgment. We all know the law. We all know what that burden is. The proponent of
So Karen, counsel, I know you just said it's not about standing, but so we have the note was attached to the complaint, and we have an affirmation, and there was your clients had already entered into a forbearance agreement. So now we have the forbearance is attached to the affirmation. So the court has that before it. Why isn't all of that sufficient?
So, Your Honors, it comes down to the affidavits. And the attorney affidavit of Miss
Counsel, I don't think it comes down to the affidavits, because I think it only comes down to the fact that you have the note and the forbearance agreement, which is introduced by the affirmation. So I don't actually think the affidavits are crucial here. Usually they are, but I think this is the unusual situation where the existence of the forbearance agreement really establishes pretty much the bank's whole case. So
Well,
I don't explain to me why, given the forbearance agreement, there's anything, why the affidavits are of any importance. I usually look very closely at the affidavits in these cases, but I think this case is really irrelevant because of the forbearance agreement. Explain to me why that's not a correct analysis.
Well, Your Honors, it's because the bank had to demonstrate that they were in possession of the note.
But they did, because it was attached to the complaint. But you just said standing wasn't relevant here, but it was attached. The note was attached to the complaint.
So, but Your Honors, again, I have to bring you back to the affidavits, and the affidavits are not sufficient in demonstrating personal knowledge.
How do you get around the note? I mean, sorry, how do you get around the forbearance? How address that issue? How do you get around the forbearance?
Well, there certainly is a forbearance agreement. I agree with that. I guess, Your Honor,
But counsel,
and it waives everything.
The forbearance agreement says that the borrowers don't have a valid defense. They don't have a set-off. They don't have a counterclaim if they default in payment and against any future mortgage foreclosure action. And they also agree as to the amount due. But what else is there? If the note is attached, what else is there? I agree with my colleagues that this is kind of open and shut, isn't it?
Again, Your Honors, I have to disagree with you. They had to demonstrate in the affidavits as part of their proof that they had possession of the note, and So
what is the rule with regard to that? If the note is attached to the complaint, that is where it's supposed to be. That's what happened here. So I don't understand what you're saying about that. I think my colleague is trying to say something.
Sorry,
Justice Ginsman.
Add to Judge Renwick, if they attached it to the complaint, obviously they possessed it, because they couldn't have attached it to the complaint if they didn't possess it. So at that point, they don't need an affidavit saying we possess it, because the note's right there. I don't understand your argument.
Why don't you continue? I'm sorry, unless the judges have any other questions. Why don't you continue on rebuttal? Mr. Hoffner?
Yes, Your Honor, thank you. First of all, do any of the judges have any questions for me about any of the issues?
No. Do you wish to continue, or?
I just want to address the hardship situation because that's something that did not just come up. The appellants clearly had a hardship. That hardship started, or at least Mrs. Foyer was diagnosed with cancer. That was after the default. That's in our paper, so I'm not going to get back into it in any detail. But you know, on top of that, this is not a hardship type situation. The hardship was considered by the bank and was considered by Judge Bluth in granting her decision. But you know, this is a situation where this is a very large house or a very large apartment.
It's $6 million value. We're aware of that.
Okay. So I just wanted to highlight that point for Your Honor. And with that, I yield my time.
Okay. I think we're back to you, Ms. Friedman.
Unless
for
you
1
have
minute.
questions, Your Honor, I will close with, in my view, the affidavits are important. As proponents of the summary judgment motion, the bank did not meet their burden of demonstrating prima facie entitlement to judgment as a matter of law. The bank did not, has always pressured the Fowers, and quite frankly, summary judgment is drastic, and in our view, they moved too soon.
Thank you.
Thank you
both.
Thank you.
Next case is People versus Leonard Woodard. And I have Ms. Ratner. Just give me 1 minute. Okay, you may begin.
Thank you. Good afternoon, Your Honors. Jody Ratner for Appellant Leonard Woodard. My reply brief addressed the numerous misrepresentations that were in respondent's brief, and I don't want to belabor those corrections here. What I would like to highlight for the court are the two cases that I provided to the court yesterday, both of which were decided in the last few weeks, which recognize the potential that an officer might be implicitly motivated by race in their actions in search and seizure cases.
How do we apply that here? I just want to know how we apply that here. We're all very sensitive to that issue. This is in a concurrence, and okay, so the officer may have tailored his responses. I mean, he's just so perfect about everything. How do we undo that, where we have to give deference to the trial court? The trial court has assessed the witness's credibility, which would make that go one way or the other, and has said, this is what he said, but he's authentic, essentially. So what do we do with that? Well, I think that's one of your cases, and then the other one, let me just go. You can go ahead and respond to that.
I would just say, it's the law that this court is not bound to give slavish adherence to the hearing court's findings. In numerous cases,
of course we're not, but I guess what I'm asking you is point us to the facts that we can use to make the argument specifically, not just another case that, is, I don't want to say lip service, but says things that we are all aware of. Point us to the specific facts here, the testimony, what the judge did, point us to that.
So, okay, so the first thing is the inconsistency, and not just the, as the hearing court found, that the hearing testimony was fuller. It wasn't fuller. The hearing testimony and the grand jury testimony were in direct conflict on critical facts. So the first fact is when the officer said that he smelled the marijuana. At the hearing, he used the catchphrases within the vehicle or inside the vehicle. When the grand jury, he explicitly stated that he smelled the marijuana coming from the vicinity of the clothing. He could not have said that if my client was still in the car. He certainly would not have used that phrasing from his clothing. He also said that he smelled it, coming from the vicinity of the clothing as they walked to the back of the car. So obviously that is after my client got out of the car. Again,
okay, and so this was a traffic stop for an illegal, not for an illegal, but for a left turn without a signal. And he says that he saw the person reacting in the back seat, ducking or whatever. It's a traffic stop. When he stops and, according to him, sees this person ducking, doesn't he have a right to ask him to get out for his own safety? In a traffic stop like this, can he ask him to get out of the car?
He can ask him to get out of the car, but the issue is whether he has a reasonable suspicion that my client was armed or dangerous. The only thing he knew was that a livery cab made a turn without signaling and that my client leaned over. All he did was lean over. Unlike all the other cases that respondent cited in their brief, the officer did not see him hiding something, trying to stuff something in the console, none of that. All he saw was my client lean over.
So are you saying that merely seeing him lean over was not a basis to ask him to come out of the car? That he needed more than that?
I'm sorry.
Did you not hear me?
Okay, sorry, you just broke up. I couldn't hear. I am
sorry.
saying
I said, are you saying that the author, can you hear me okay now? Or am I still breaking up? Am I still breaking up? I don't know.
I hear you now. Okay.
Okay. Are you saying that the officer needed more to ask him to come out of the car than just seeing him lean over?
No, he could have asked him to come out of the car. That is fine. And once he was out of the car, if he smelled marijuana, that is something else. What he didn't have first was probable cause to search my client and the car merely because he smelled marijuana inside of the car. So if he didn't smell it within the car, he then needed probable cause to, he needed reasonable suspicion that my client was armed.
But he saw a bulge. He sees a bulge. He has a basis to get him out of the car. He gets him out of the car. No problem yet. Now he sees a bulge. I understand. He saw all the right things at all the right times, described it all the same way, but he got him out of the car. You don't have an issue with that. And then he says he sees a bulge. So even if he said, I smelled the marijuana on his clothes then, or I smelled the marijuana, even if he says I smell the marijuana, he says the reason why he takes him out of the car is because he's leaning, and he doesn't really have to have a reason because it's a traffic stop.
Right, but in order to frisk him,
he sees the bulge.
Has to have reasonable suspicion that we can call it a bulge, but we can also say it's something in his pocket. It's in his pocket. It's his jacket pocket. It's not in some strange place. It's in a jacket pocket. And
I agree. So now he says
that
now he says he's sweating. He's sweating, and he's, appearing nervous, sweating, appearing nervous. So that's now his basis for patting him down. He's suggesting that I'm worried now. I'm trying to find out, what so far I have pause when I read the testimony of the officer that seems tailored. When I go through it step by step, I'm not sure that I see where you're talking about. It troubles me, but I don't see that.
So what I would say is, let's all imagine that this is a yellow cab in Midtown in the middle of the day. This is a white male backseat passenger who does the exact same things.
I don't want you to do it that way. I really want to go through this incident. You don't dispute that the officer had the right to ask him to get out of the car. He gets out of the car. He says that he sees a bulge. Once he sees a bulge, he does the frisk. Do you object? He does the pat down once he sees the bulge. Do you object to the pat down?
Yes. And I would say before that.
So when he does the pat down because he sees the bulge, what is it? What is your basis for saying he didn't have a right to do a pat down?
Because it did not look like a gun. It did not have an outline of a gun. It was not in a suspicious location like a waistband or the crotch area, which this court has said that gives an officer that sort of red flag. This, something in one's pocket, does not give any red flag to an officer. This is just somebody
does the automobile exception come in here where he gets him out of the automobile and then he's saying he's sweating and he's acting strange and I'm nervous, so I can now pat him down?
No, once he's standing on the street, it becomes a street encounter. And in my brief, I cite to the case in which this court has said once he is out of the car, we then go by the law of the street encounter. And the law of the street encounter is that reasonable suspicion that this person is a threat or is armed. Not just he leaned over, he's nervous because he's pulled over by a cop. It might have been, as in the Weaver case that I submitted to you, that is a federal court, but nonetheless, all of these things, nervousness by being pulled over by an officer, black man being pulled over in East Harlem
Counsel,
at night.
I know that you asked us not to give slavish deference to other matters decided, which I would never phrase anything like that. And maybe you'll think about why that's objectionable, at least to me. But the bottom line here is that irrespective of who is the bearer of the pocket, if you basically believe that, or you're arguing that a bulge is something that does not give rise to reasonable suspicion. A bulge does not give rise to a pat down, as my colleagues have asked you. It has to have the outline of a gun.
I would point your honor to the cases that I cite on page 30, in which this court has said. Your
position is that once he gets out of the car, I think you said it, we have to look at it a different way. It's no longer the exception, that we have to look at it with whether or not on the street puffiness in a pocket is suggestive of a gun, or whether it has to be in those places you talked about, in the waistband, or it looks hard, it's hanging heavy in the pocket, something to that effect to suggest it's a weapon.
And what I was going to say about the Weaver case is that these might have given rise in the officer's mind that my client had something on him. And of course, we know he did. But whether he had drugs on him versus a gun is a huge difference. And the officer, in order to frisk, the officer must believe that what my client has is a gun. And none of these factors, leaning over, being nervous, having something in his pocket, none of those give rise to a suspicion that he had a gun, unless you believe that all black men in Harlem riding in the back of livery cabs possess guns if they have something in their pocket.
Thank you. Sorry. Mr. Tisney?
That's right, Judge Renwick. Philip Tisney for the people. I'll start with your concern, Judge Renwick, and I hear what you're saying about his testimony. But you know what I'm going to say, which is that Judge Convisor heard all of these things at the hearing, heard all the points that they've made in their brief.
But Mr. Tisney, let me stop you there and say, okay, so that's why we're here, to review and see whether it's accurate. And so let me just get right to the issue with regard to what counsel says about the puffiness in the jacket and the cases with regard to that. So he takes him out of the car. He starts to walk him to the back. That's when he says he saw the puffiness. Do you disagree at all with the test that then has to be used to determine, whether it's a weapon, whether he's guessing it's a hunch, or that it's a weapon, or does he have some concrete is not the word, but articulable basis for saying why he thinks that puffiness is a weapon versus some tissues?
Yeah, no, I don't disagree. I think that where we disagree really is, once he gets out of the car, it's not like all the stuff that happened before that goes away and isn't relevant anymore. I think we agree that the officer needed reasonable suspicion to think that the defendant posed a danger to him. And I think when you look at this court's cases and the credited facts at the hearing between bending over out of the officer's sight when he gets pulled over, acting nervously when he's talking to the officers.
But isn't it an important factor whether or not the defendant cooperates? And the defendant never fails to cooperate.
Well, he's
nervous,
when they ask,
but he never fails. Yes.
Well, but that's not exactly true either, because they ask him what's in his pocket and he refuses to give an answer. He says, aren't you supposed to be looking for guns? Which, as the hearing court said,
failing to cooperate. That's sort of exercising his rights. He doesn't have to. He's not failing to cooperate because he doesn't ask for the question directly. He could have said, I don't choose to answer the question. That wouldn't be not cooperating. And what he tells them is, aren't you supposed to be doing your job, essentially, not harassing me, but looking for weapons? That's essentially what he's saying, in a way that maybe doesn't get him hit over the head.
Well, I just don't know that I would call it cooperation. I mean, that's the point that I'm responding to, of your honors. And you know, if he had said, I have a cell phone in my pocket, then certainly I think we have a much different case. But he didn't. And when you look at all of the things that happened up to that point, when the officer runs his hand over the pocket and he feels something hard and something soft, and he says, I don't know what it is at that point, and he asks the defendant, and the defendant doesn't give him the answer that makes any sense, frankly, then he has a right to pull it out so that, you know, he isn't surprised when a knife or a gun comes out. And that's pretty clear on this court's cases. So
yeah,
I
don't disagree with you on that point. Going, I think it's the part that leads up to that, getting out of the car. And I'm not saying I'm disagreeing. I'm just questioning you both. Part where he gets out of the car and then the pat down begins. The justification for that.
No. Well, and I don't think we disagree here. I mean, I think the other side concedes that the officer is entitled, once they make the traffic stop, the officer is entitled to ask the occupants of the car to get out. He doesn't even need the suspicious circumstances of the defendant walking down. He can ask him to get out already, but he does have this, which I'm sorry is a suspicious activity of ducking out of view when the police are pulling you over. Confronted with that, I mean, this is.
I think we have a question from Justice Gassman.
Justice Gassman, don't you have to consider the fact that the officer did shine his light into the car and saw nothing in the defendant's hands and nothing else suspicious in the car? Why doesn't that mitigate the fact that he ducked and turned around when the officer stopped him? I mean, there are lots of reasons one might turn their head when the officer is stopping them.
Well, I don't think the testimony is that he turned his head. I think the testimony is that he ducked down completely out of the officer's view. And certainly the testimony was also that when he pointed the flashlight in the car, he didn't see anything. But that's kind of the point, isn't it? I mean, the officer at that point doesn't know what he was doing when he ducked down. And from the officer's perspective, he could have been secreting something under the seat. That's the danger. And so
something under the seat, then the officer's not in any danger. That doesn't get you to a reasonable suspicion of dangerousness if the defendant was secreting something under the seat.
Putting something under the seat or taking it out from under the seat. I misspoke.
Said that defendant's hands were empty. So where's the dangerousness? That's what I'm having trouble with. Where is the danger?
Well, I don't think he asked him to get out of the car because he thinks he poses a danger at that point. I think he asked him to get out of the car because he's entitled to, and because frankly, he smells marijuana in the car, and he says, this guy is smoking marijuana. I have an opportunity, or I have the authority to search him under the automobile exception, and I'm going to do that. It's only once he gets out of the car, the officer notices that there's a bulge in his pocket, asks him the question about what the bulge is, does the pat down, it's inconclusive, and then pulls out what he.
So I just want to slow us down. He gets him out of the car, and then I'm going to let it go. But he gets him out of the car, and he's walking him to the back. He already had smelled the marijuana, so he knew there was marijuana. He sees the sweating, and he sees that the gentleman is nervous, and he sees the bulge, but he doesn't describe it in any way other than a bulge.
That's correct.
Is that enough for him without saying that he's nervous or afraid or anything else? And with I don't know what we can say other than cooperation, because I don't know what a defendant has to do to cooperate. If he says get out and he gets out, he says walk and he walks, you know, he's got to use specific words to talk to the officer. No, know, so I think he's cooperating. So he does everything the officer says to do. I'm just trying to figure out at what point then does that bulge, how does the officer articulate that there's either through him saying that he's afraid or saying that he knows that from looking at it, there's something else in that pocket.
Well, he didn't testify here that the bulge looked in a particular way. The hearing evidence.
Did he say he was nervous? Did he say he was scared? I don't remember seeing.
No, he didn't. There are cases saying that the officer's subjective fear isn't what's relevant. It's an objective standard. The officer didn't testify. I was actually afraid of a possible danger here, but again, I don't think he needed to. And we've been focusing on the the sort of second justification for the search here. As we laid out in the brief, the automobile exception is an independent basis for the search and the recovery in this case. And contrary to counsel's statements, there was nothing inconsistent about the grand jury testimony. The officer testified that he asked the defendant at the grand jury testified that he asked the defendant to get out of the car, and then when he did, he smelled the smell of marijuana coming from his clothing. As we explained in the brief, and as Justice Convisor concluded at the hearing, what he was saying at the grand jury was, I opened the door and I asked the guy to get out, and when I did that, it smelled like marijuana coming in from inside the car, and that was, of course, consistent with what the officer said at the hearing, where the suppression issues and the sort of location of the smoke, that issue was actually litigated. He was very clear that that the smell came from within the car, and the way we know this is because he testified that the defendant was in the car, and the officer asked him, "Why does it smell like marijuana?" And the defendant says, "Well, in fact, it wasn't me, but I was at a party where other people were smoking." And this is not a concession, as they say, that we're trying to misrepresent the record. This defense counsel never objected to any of that, and not that they objected, but they didn't sort of controvert that fact, and that fact is critical because it puts the defendant in the car while the officer is expressing his sense of the smell of marijuana. So we have the grand jury testimony that isn't in conflict, and we have that uncontroverted testimony at the hearing, both that he was in the car when he smelled the marijuana and he was in the car when he explained why he smelled like marijuana. So I hear that there are concerns about the other issue, but this is certainly an independent basis for the suppression decision.
Ms. Ratner. I have one more question. I don't understand the significance which you attribute to the defendant's statement that he was at a party where people were smoking marijuana. I don't understand why that seems so significant to you.
It's not that his statement, it's where he's located when he makes the statement. The officer testified he testified that when he asked this question, the defendant was sitting in the car. Neither at the hearing nor in their brief on appeal does defendant controvert that he was in fact sitting in the car when he made that response. Now, I don't care why he says he smells like marijuana, but the fact that he's sitting in the car when the officer has asked him, why is there this marijuana smell, shows that it was the defendant was in the car when the officer smelled marijuana. That's enough to trigger the automobile exception. That's what gets us to this independent basis to search the defendant when he finds the drugs. Unless there are further questions, I'll just
Thank you,
Your Honor.
Ms. Ratner.
I'd just like to say that's absolutely untrue, that I did not controvert that statement. In my reply brief, I explained why that statement of the defendant referring to being at a party where it smelled of marijuana, that occurred outside of the car. It did not occur inside of the car. And again, the grand jury testimony and the hearing testimony were completely at odds, as I pull apart in my reply brief. I would like to, though, take one step back and explain, Ms. Justice Gonzalez, that the reference that I said earlier to slavish adherence, I agree that is upon reconsideration, it is poor choice of words, but I'm sorry that it is from a First Department case, Vasquez, in 1995, and it is something that we frequently rely on in our cases, but I agree that perhaps we should be looking for a different
Thank you, counsel. I appreciate that.
For that same principle.
Was there anything else you had? Did I freeze or did you freeze, counsel? Oh.
I did.
Okay. Do you have anything further that you want to add?
So I did want to add, because I didn't get a chance to talk about the automobile section, the automobile exception, and you did make reference to it in my colleague's case earlier today. And I do believe that that was People versus Dilworth, and whether the exception, looking at it today when marijuana is legal in some respects, whether it would still be applicable. And I believe that this court can look at it anew in this case and determine that it should no longer apply the law was only passed in August 2019, but it was a decades-long lead up to the recognition.
But it wasn't retroactive.
It may not be retroactive, but this court can look at it and determine that it should not be applied in this case, where it has such a disparate impact on Black and Brown communities, and where the facts of this case in particular are, we believe, so telling that it was not actually something that the officer smelled. The hearing testimony was created in order to close that gap, and the grand jury testimony put a lie to that, and it should not be upheld in this case. The automobile exception should not be relied upon in this case for the legal reason, but also for the factual reasons.
Judge Remick, I'm sorry. This is, and I realize.
No, I'm sorry. I cannot do that. I thank you both for your arguments. We have the briefs. We have the records. We will hold it. Thank you. Thank you both.
Thank you, Your Honor.
Next case is Soteros versus 7up Realty. And you may begin.
Thank you, Your Honor. Marijo Dukovic for the third-party defendant, appellant respondent, AJ Greenwich Contracting. The only issue before the court at this point is the contractual indemnity issue between the third-party plaintiff and third-party defendant, 7up and AJ. This court should narrowly construe the indemnity.
And you represent AJ, and AJ's principal, I guess it is the person who said everything was in the contract. Everything was in the contract, the painting, everything. Then he has a break and he comes back and he says, well, I think that was the painting was separate. I mean, he raises with his testimony a question of fact as this issue, as to this issue, at the very least, doesn't he?
Your Honor, we disagree with that. He made it clear. The question was somewhat sloppy in terms of what was the contract. Are we talking about the August 30th, 2013 contract, the September?
Well, then I have another question. In the contract, it says that there has to be a writing that's signed by the parties, I think, and an architect. But there was never an architect signed by the owner and architect. There was never an architect in this case. Is there a waiver then of that provision to have all of this since there was never an architect and there was no explanation as to what the absence of that would mean?
There's no reason to vitiate the entire clause. That's Article 13.1, changes to the work. There has to be a written change order or a written construction directive. The fact is that we need to have a writing, and the need for a writing is really important. Again, especially when you're seeking indemnity from an employer, which dovetails with Workers' Comp Section 11. Otherwise, this is just a free-flowing arrangement, very informal, and does not give the certainty to the parties that they need in any contract. There's a reason why we focus on the four corners of a contract when we deal with these issues, and normally do not get into extrinsic evidence.
You have a contract, but as I say, there were all of these other pieces, the receipts or invoices that were brought up afterwards, and your very client says that he's the one who creates this, among other things in the evidence, this issue that it's not clear.
Your Honor, I again disagree, because once he understood the form of the question, he was very consistent in his testimony. And in fact, his partner, I'll call him a partner, his co-owner of the business, also, he's the one who prepared the documents. And he was very certain about what was part of the contract, what was in the estimate, which was separate, and what was in the invoices. And the man who testified to that is the man who's on the scene, who's doing the work, and he's supervising. He's not the man who drafted the contract. He's the one who on the scene supervising the work. And Your Honor, if you look at the contract, you see it's window replacing and blocking. No discussion of painting, which is the work that the plaintiff was doing at the time of the accident. Then there's an estimate that comes out.
I'm sorry, go ahead. I was just seeking if there were questions from anyone else. Go ahead.
Then there's an estimate dated September 13th, signed on October 22nd. That doesn't mention painting. And although 7UP's counsel goes to great lengths to try to say, well, it's all part of the contract, how can you do all these other things without painting? The simple fact is that when you look at the estimate, all of that work had to do with demolition. It doesn't talk about anything leading up to a necessity to paint. And there's testimony that when in fact they replaced the windows, they were brand new windows that were already painted. So again, there's no need for painting for the window replacement. Nobody said there was. There's no need for painting under the estimate. Nobody said there was. It's not until there's a brand new invoice dated February 14th of 2014 that we see the word painting at the bottom. And even that work doesn't tie to either the windows or the estimate. It's again, a new phase of work or a new job altogether, which has to do with demolition.
These things raise questions of fact?
I'm sorry, Your Honor.
I said, don't these things raise questions, issues of fact?
Your Honor, all these documents are really plain and unambiguous on their face. Each document talks about a specific type of work with a specific
Well, except
price.
that the second document then includes the first document because, you know, the first one, you might say it's clear if nothing else happened, but then you had the February, which brings in the windows or something else, that joins it in. Then the last one, which brings in the windows and the painting. So it's not as clear as you say.
Well, I think if the court,
Anyway.
and I know it's tedious, but
I'll let you finish up.
okay, it's very tedious, I know, but it's very clear when you read each document that they are different aspects and
Oh, I
phases.
did. That's
of
why
the
I'm
work.
saying what I just said. Okay, thank you, Mr. Hoff. I'm sorry.
Harfinist.
Okay.
Okay.
Okay, Harkness, yes.
Judge Roanoke, I'll start off by cutting to the chase with regard to the testimony from Mr. Jezekel. You got it spot on. He testified that painting was part of the question. Wasn't ambiguous. It's quoted verbatim in the briefs. It was a clear question. He answered that painting was part of the contract. There was a break. He came back in. He changed his testimony. The idea that the question was poorly phrased or that he didn't understand it is contradicted by the witnesses. Gesundheit. Is contradicted by the witness's testimony throughout the deposition, where he asked for questions to be rephrased. They also argue that he really wasn't very verbal in English. He didn't understand. He never asked for an interpreter. He started the deposition off saying he spoke and understood complete fluent English. We all know what happened at that break. That's the bottom line. So he changed his testimony. There's plenty of cases out there. We cite to a couple of them that say technically you can't even defeat summary judgment, let alone raise a question of fact on it. The idea that each one of these invoices constitutes a separate contract is problematic when you actually look at the main body of the contract, which I think everybody could agree should never have been used in this circumstance. It's a Form AIA contract. There was no architect here. It's got all kinds of clauses and references to provisions that don't apply. It references specific documents that nobody ever used. But if we're going to look at the language of it, we're going to start off by looking at this concept of contract documents in Article 7. And what that basically says is that it incorporates documents that are used by the parties into the contract itself to complete the work. So all of these invoices and estimates are contract documents that are incorporated under Article 7 of the contract.
Excuse me, counsel, but that argument assumes that the work includes everything that was later in any of these other invoices.
Well, but that's how the contract works.
The question is whether that's how some contracts work. But the question is whether the work as defined in the actual AIA contract was much narrower than what was incorporated in the invoices later.
Well, it's hard to tell because the contract itself says replace windows and blocking. What does that mean? So, I mean, they use two words. Normally, I've seen dozens of these AIA contracts. They have riders that list item verbatim as to what necessarily has to be done. Here you got two words stuck into the body of a contract and a series of invoices and estimates. So at a minimum, there's a question of fact when you couple it with what Mr. Jessica said. But there's one real problem that for the appellant's argument, there's one real piece that's a real problem to argue that, and Justice Drummock, you touched on it, and I'm going to expand on it a little bit. Each one of these documents fed on each other. They all build on each other. And if you look at the document that's called Progress Invoice Number 6, it's at page 776 of the record. It's called a progress invoice. So and it incorporates all the work that's being done, including, and I'm sorry if I'm leaning over because I'm looking at the pages.
Okay.
It incorporates all of the work, including the painting. So it's impossible to say that each one of these, the argument that the appellant's making, that each one of these documents is a separate contract.
Thank
but
you.
If I can just make one more point.
Okay. Do you want your rebuttal?
I'll use all my time now, so that,
okay,
because I think it's important.
Another minute. Go.
This case is no different than the third department's case that we cite in our brief called Brewmaster, where the parties abrogated a requirement for written change orders. That was verbally. Actually, this case is even stronger because there are written documents. In that case, the third department basically they said, where parties chart a course that's outside the terms of the contract, you're stuck with it. That's the way you conducted the business. That's exactly what happened here. The interesting absence from this record is that there's no reference by AJ that they objected to doing any of this work because it was, and they required a new contract. They didn't. They were all operating under the other contract and it was all incorporated. So even if to the extent that the agreement does not incorporate the invoices as contract documents, which I think it does, the third department's case in Brewmaster is on all fours, exactly as this. The parties can abrogate it orally. Here they abrogated it by documents.
Thank you, counsel. Ms. Hodakevich.
Yes, thank you, Your Honor. First of all, Brewmaster did not grant indemnity against the employer. It was not based upon any changes to the employer's contract. That indemnity was granted against another contractor, a general contractor. Secondly, the case that is really on point is in my brief called Lombardo. That's a case where there was no indemnification when the job called for painting. The plaintiff was injured while he was doing stucco work. There was now clear evidence that stucco was part of the contract and they didn't get indemnity. With respect to the contract documents, if the parties wanted to incorporate invoices in the estimates as contract documents, they should have listed that. And in fact, every new job, every new aspect of what work they were doing at this building incurred a separate charge, with the estimate going from $45,000 for the windows to $110,000. Then when we get to the invoice February 14th, which is the first time the word painting appears, and they could have hired anybody to do painting. They didn't have to hire us. It's not necessarily part of this contract. That's when it appears, and it's not called a progress invoice. It's called an invoice. And it's only when on the last invoice that they include everything. And when asked, they explain simply, it's the same client, it's the same location. We build it all at once, which makes perfect sense. And that doesn't have any legal import whatsoever as to what's included in each separate agreement. It's just a bill. That's all it is. Thank you, Your Honors.
Yeah.
Thank you
both. Thank you both. The next case is Ferran versus ComputerShare. Mr. Heim?
Yes, thank you, Your Honor. May I begin?
Yes, you may.
Justice Fenwick, may it please the court.
Did you note your appearance? I don't know that
yeah.
I guess it's already noted somewhere. But, yeah.
Sorry, Robert Heim on behalf of plaintiff appellant Marie Ferran.
Okay. Counsel, I have to say you represent the plaintiff, and I don't see, well, I will just say, is there any credible, indisputable documentary evidence that the defendant had its shares, or even that the plaintiff had any shares?
Well, yes, Your Honor. There's three key pieces of evidence on that respect. One, we have correspondence from ComputerShare confirming
But they
the
say
share.
that they didn't look it up by way of the social security number. And then your client didn't even give the man's middle initial. They come up with somebody else's initial. I mean, what is this?
And the ComputerShare says that was a mistake. They testify it's a mistake.
So if we disregard ComputerShare's stuff, what else do you have?
Well, we have the testimony of the ComputerShare representative also that this occurred over a 3-year time period where 3 separate employees of ComputerShare did the search for the shares. And really the standard is whether there's a material fact that's in dispute. And there are.
What documentary?
A material fact, because everybody agrees that the shares that ComputerShare was talking about belonged to Cornelius W., not Cornelius A, and it didn't match the decedent's social security number. So putting aside the documents from ComputerShare and the repeated errors by ComputerShare's employees, what else do you have?
For example, do you have a certificate, some document that says, hey, Verizon had these shares, here's the certificate, let me show anything?
No, we don't have a certificate or anything like that. We do have a handwritten note that was written by the decedent.
And found years after the decedent, after the death, in a box somewhere. So,
yeah.
So apart from what my colleague said, when you take away all the other, your client has nothing.
Well, we also have the statement of the decedent's sister, which was the statement that originally triggered Mr. Ferran to write to AT&T because she
it says, I think he had some shares, a lot of them.
Right.
Yes.
Based on some
correct.
statement he made, not on any documents he ever showed her.
Counsel, that list that is provided, it has no date. It has no indication that money was paid. It has numbers. It has names of I don't know, possible investments, old investments, existing investments, but it's a list. It's the kind of a list that anybody would make, the kind of a list that you make when you go grocery shopping, for example. You make a list, but there's nothing more than it's being a list.
Well, I think, well, that's correct, Your Honor, but I think we're saying in our arguments as well that it's not only a question as to whether the shares were owned by Cornelius A. Sullivan or Cornelius W. Sullivan. We think there's a good chance that there could have been commingling of the shares. We never had the chance to have an expert go through the transfer agent records to verify.
Cornelius W. had all kinds of documents.
Yes, there were a lot of documents, but he did not use his middle initial, and it's really irrelevant because the ComputerShare representative testified that they don't keep track of shares or ownership by the middle initial. And my client gave the social security number to ComputerShare. She gave the address.
Okay, you have rebuttal. Counsel?
Thank
you. I'll be very brief. And this is James H. Fort, representing respondent and I believe ComputerShare Inc. Your Honor, there's one outcome determinative fact among many others, and that is what was in the certification of ComputerShare's representative who testified at deposition and put in the certification or affidavit on summary judgment. And he testified that if you use a social security number in ComputerShare's database, you will pull up any account information for any former or current account holder. So
nothing came up ever.
Nothing came for Cornelius A. Sullivan.
Right.
And he did that search, and it was done 3 or 4 times, and nothing ever came up.
Anything else, Counsel?
I have nothing else, Your Honor, if there are any questions for me.
Any questions? Thank you very much. You have some rebuttal, Counsel?
Yes, Your Honor. Just on the point with respect to the social security number, ComputerShare's representative was not able to testify how the 3 earlier representatives who did the searches contemporaneously, he was not able to describe how those searches were done or whether.
Either way, when he did the search, he would have put the number in and it would have come up for past, present, whatever. So The fact that other two didn't do it, the fact that the third did it, that would have been sufficient.
Well, I think we're putting too much stock into ComputerShare's records on this. We had a serious
And we have no
issue.
stock in any one that you have, because you don't, your client has none.
Well,
The records
but-
aren't good enough. The business records aren't good enough here?
Well, I think that it's true that the ComputerShare admitted that they were not able to find a critical phone call, and I really don't think their explanation is credible, because this is over a 3-year time period. They kept informing Ms. Ferran that these were Cornelius A. Sullivan shares. She submitted all sorts of account records, and to say that over 3 years they paid her dividend checks, they gave her 1099s in 2014. And there is a lot
until Cornelius W. shows up and says, "Where's my shares? What happened to them? They're gone." And
I'm sorry.
No, and your client says, "Oh yeah, they're mine." But what we're all saying is, how?
In fact, CWS even had to say at one point, "You changed my address." So clearly, none of this was CAW. It was all whatever. It wasn't the middle initial with the A.
Well, I think I respectfully disagree with that, because I think that there is a high possibility that there could have been commingling of the two Cornelius's shares.
Okay, does anybody have any other questions? Thank you, sir. Thank you very much. Thank you both.
Thank you.
Next case is People of New York versus Brand.
Good afternoon, Your Honor. Good afternoon, Your Honors.
You may begin. Thank you.
Thank you. Mark Simpson returned to court twice after his indictment, having posted a $3,000 partially secured surety bond. Judge Kiesel did not do what this court ordered her to do, because she did not explain why $100,000, 3,300% increase in the partially secured surety bond was the least restrictive means to ensure Mr. Simpson's return to court. Every factor used to determine the least restrictive means militates towards the release of Mr. Simpson. Activities in history: Mr. Simpson has a rich family life and is active in the community. The charges facing the defendant: Mr. Simpson is presumed innocent in the contempt allegations that he presently faces. Conviction record: Mr. Simpson has no record of conviction. The YO or JD adjudication: Mr. Simpson has no YO or juvenile delinquency adjudications. Indication that he might present a risk of flight to evade prosecution. Mr. Simpson has never bench warranted, and there is no reasonable evidence in this record to support the contention that he is a risk of flight to avoid prosecution. Mr. Simpson appeared in this case not once, but repeatedly before his bail status was increased by Judge Kiesel. Financial circumstances: Mr. Simpson has extraordinarily limited means because he was last employed.
Counsel,
yeah. I'd like to ask you a question about financial circumstances.
Yes.
I found your case very sympathetic until I got to the record before Judge Kiesel, where your client had the opportunity to put on financial information and didn't. All he said, and it's in, I think, 2 pages of the testimony, was that he was employed at Fresh Direct very briefly. He never says when he was employed. He never says when he left. He doesn't say how much he earned. He doesn't say what his last job was before that. He doesn't talk about any attempts to get employment after that. He doesn't talk about but there is his lack of financial information when given the opportunity. Really, it seems to me, undercuts your whole argument, which I might have found persuasive if you had taken advantage of the opportunity to lay out on the record, which Judge Kiesel gave you the opportunity to do, what his financial circumstances were. So yes. All we have is the testimony of his mother and aunt, who describe their own financial circumstances, but they're not in a position to describe what his are. So how are we to understand what his financial circumstances are when you didn't choose to put on any testimony about that?
And I think, just if I can add, I think Justice Kiesel showed her that she demonstrated that she didn't find the defendant credible, because she said he seems to say one thing with regard to his work when it's at one point, and he changes it at another point.
Goes from 4 years to 3 years to actually I only worked there a month and a half or a couple of months, right? So she didn't find any of that credible.
I will admit that I found that a bit perplexing because Judge Kiesel also admits that those are highly suspect interviews and that she concedes that there's a lot of noise in the background and that
that's not the problem. The problem is he didn't affirmatively say what his financial circumstances were. Putting aside what CJA wrote down, he didn't affirmatively take the opportunity to actually say what his financial circumstances were.
I do believe that in the record that he indicated whenever he spoke on the record during the hearing that he had only been employed there and hadn't actually been able to get payment, from Fresh Direct at that point in time.
But he didn't describe what efforts what he was supposed to be earning, what he'd earned before that, what his expenses are, what attempts he's made to find work. He doesn't what assets he has. He describes nothing except I worked at Fresh Direct very briefly. That's not a financial disclosure.
Well, I would just urge Your Honor, I mean, that first off, I would say that at this point, my client's been incarcerated for more than a year, so it seems that any reasonable person would really conclude that he has no financial means at this point.
That's not the question in front of us. The question is what information Judge Kiesel had in front of her. He was given the opportunity to give her information, and he didn't choose to do that. How can we draw inferences about whether or not he could afford this when he didn't take advantage of saying what his financial circumstances were?
Well, I think that, my client had never had an income that put him in a category where he was filing taxes. And so,
there's no testimony to that.
There's nothing in the record about that.
Well, I think, though, that there's testimony from his aunt, who I believe actually was in a position. I'm sorry, I think my screen is frozen a bit, Justices, but there was testimony.
No, you're not. We can hear you.
Okay, thank you, Your Honor. There was testimony from the aunt of my client indicating that he was living at her apartment in the time leading up to his initial arrest in this case, that he had actually referred him to a program.
But that doesn't mean that he didn't have other assets. I don't know why he chose to live at his aunt's house. People make lots of choices, but he didn't tell us what his financial circumstances were.
I just beg to defer, Your Honor. I mean, I think that he does in fact indicate that he'd only briefly and recently been employed by Fresh Direct. And
other than that, did he put in any financial information about himself as opposed to his aunt and the other woman who testified?
It was his aunt and his mother, Your Honors. I mean, they knew my client intimately, and so I would just
asking you again, did he put in any other financial information other than the statement about Fresh Direct?
On the record, he only indicated his employment history.
Okay, you have some rebuttal time. Thank you. Counsel, you have some rebuttal time, I said.
Yes, Your Honor.
So I'm moving on now. Thank you. Counsel, Ms. Nicholas.
May it please the court, Lucy Nicholas for the people on behalf of the respondent.
Counsel, this defendant, what are the charges? What's his exposure here on this case?
He faces an aggregate exposure of 2 2/3 years to 8 years in state prison.
And where is this case right now?
It is currently adjourned to October 28th for hearing and trial.
Is there going to be a trial in this case at this point?
No one knows at this point. I think it's unlikely.
Because he's facing he's already been in for quite a significant amount of time, and he's not facing that much time. It's his first arrest. He certainly has a bad habit of violating court orders, but it is his first arrest. And that's interesting, I think.
And the people understand that he doesn't have a record, and Judge Kiesel did consider that and made an explicit finding to that. She just found that other factors enumerated explicitly in the bail statute weighed in favor of the people's bail application, specifically that he violates multiple court orders, which speaks directly to his willingness to abide by court directives.
But counsel, isn't it a more correct statement to say that he's alleged to have violated many court orders? I didn't see anything in Judge Kiesel's decision or the record that showed that he'd actually have been found to have violated any court orders. There were certainly allegations. but there were no findings, correct?
That's correct. But if there are to be findings that he did violate,
About that.
I'm sorry?
We have to be careful about distinguishing between allegations and findings, right?
He did allege to violate court orders, but if we're to turn every bail hearing into a mini trial, then it would simply overwhelm the court system.
I understand that we're not, I'm not suggesting we have a trial everywhere. I'm just saying that we have to be careful about our speech. We can't say that he was found, that he violated court orders. All we know is that he was alleged to have violated court orders.
Okay,
right?
I understand. He's still alleged to have
He had
violated.
he had two more orders of protection issued after this first one, correct?
That's correct. He was arrested on August 13th. There was an order of protection issued. He was warned by the judge to stay away from the complaining witness, his ex-girlfriend. He was arrested again on October 28th. A second order was issued. He was again warned to stay away from the complaining witness. And then November 5th, he was arrested again, and a third order of protection was issued.
But those
So shouldn't the bail amount be, sorry. So shouldn't, go ahead.
Those temporary orders of protection are not based on a finding either, right? They're just based on an allegation, right?
That's correct, but he was warned to stay away from the complaining witness.
But we don't know.
Shouldn't the bail be of it? Yeah, shouldn't the bail be of an amount that can secure his return to court, but not one that will necessarily keep him in?
Yes, and Judge Kiesel found it within reason to set bail in the amount she did. The people recognize that it is high bail, but she had ample reasons for her securing order, which she laid out.
It's not simply high amount, but it's reflected in the fact that he has not gotten out in a year. You know, there was a question of his credibility from her. I think she questioned his credibility, but and I understand that he did not submit any documents with regard to Fresh Direct to demonstrate his amount. But the fact that he's still in, I think, suggests very strongly that he couldn't make the bail. And I don't think that he did ever warrant, although he did violate the orders.
Yes, and as Your Honors pointed out, Justice Kiesel based her decision on available information, which petitioner proffered two witnesses, but never spoke directly to the defendant's financial circumstances, and the information of the defendant's financial circumstances in the record is both self-serving and contradictory.
Or I should say allegedly violated the orders.
Allegedly violated.
Counsel, I have another question. Although Judge Kiesel's decision was lengthy and detailed, I didn't see any evidence that she considered any less restrictive alternatives, like supervised release or anything like that. Is there any indication that she considered a less restrictive alternative?
There is. At the end of the decision, she states that the defendant had been released on his own recognizance twice, yet allegedly violated the order again, which again I think speaks to the defendant's respect for the legal system and his respect to allegedly abide by court orders.
Right.
Thank you.
So I have one more question.
Sure.
People, it seemed to me, I wondered whether you consider it significant that the complaining witness claimed that the defendant had hit her while she was pregnant, but there are in fact no medical records to support that she was in fact pregnant at the time that she claimed that happened.
It's not affirmative.
Is that at all significant that that was not something she was able to substantiate?
So the people are still investigating that allegation, and it was aired in front of Justice Kiesel, and she considered it, and her decision doesn't, the basis for bail, the crux isn't the miscarriage. She even notes that there are no medical records in her decision, and I believe footnote 5. She had ample other reasons to set bail in the amount she did. Specifically, it's the alleged violations of the order, as well as the defendant's willingness to manipulate legal proceedings, which include making alleged false accusations to ACS, lying to CJA interviewers, and making records that are self-serving, yet contradictory.
Thank you. Counsel, Mr. Meyer, you have 2 minutes.
Thank you, Your Honors. I would just start by saying that I think that the level of self-serving actions that are alleged against my client, it would really take a level of sophistication just to foresee that those answers would have been important in a circumstance such as this that we really can't impute to my client. I would also just say that in reference to the questions with regards to my client's financial circumstances, that it was,
he had a lawyer who could have asked him the right questions, right?
This is correct, Your Honor. This is correct. I would just say that, my client's mother did go on the record with, when she posted the $300 to make the initial partially secured surety bond imposed by Judge Richard Sy, that makes that relevant, and their financial circumstances relevant, as they would be, reasonably believed to be the people that would post any future partially secured surety bond in the court's conclusion about what would actually be a financially reasonable step to take, or financially reasonable, at least restrictive means of setting cash bail. Your Honor, the defense has been at pains not to turn this into a factual dispute, because we recognize that our client is innocent until proven guilty, and that the facts of this case are only of limited use here, I believe, to the court in many ways.
Are you making a bail recommendation?
We've asked for relief for the court to reimpose the $3,000 partially secured surety bond. That was sufficient and has proven sufficient to ensure my client's return to court previously.
The 333?
Yes, indeed, Your Honor. We would urge the court that the most outrageous claim that the defense witness, that the complaining witness has made in this case, was that she was pregnant and suffered an assault that my client committed against her that led to the loss and termination of her pregnancy. But in medical records that have been handed over to me in the last 2 days, it appears that the only medical procedure that the complaining witness has been privy to over the last year was the removal of an IUD in October of last year, Your Honor. So while we've been avoiding going into factual disputes here, we have a very good faith basis to believe that the credibility of this complaining witness, in addition, not only to these medical records, but other interviews that have been conducted, that the allegations of the complaining witness are highly disputable.
I'm just going to say, yes, you make a good point, but this is not the first person, partner, girlfriend, whatever, that has made allegations like this against your client, I think. And I think the court took that in terms of, took that into consideration in terms of his behavior.
And also, a miscarriage might not have garner medical records. Plenty of people have miscarriages, and there are no medical records to accompany that.
She did testify to the grand jury that she'd undergone a medical procedure and was, I believe, placed under anesthesia when she had the DNC procedure. And it turns out that there's no forthcoming medical records, and she actually, in fact, had the IUD until October of last year. So I certainly do take your Honor's point, but I think in this case we have enough information to rule out that possibility. I would also say that with regards to the use of unsealed records, I think that these old DIRs fit squarely under 160.50 sub J, and these are documents that should have been sealed because they've been subjected to absolutely no scrutiny, just the bare allegation of the person making the complaint. And those were, at that point, either arrests that were not pursued and would fit under that statute and be subject to sealing.
Sorry, were they sealed? Were these documents sealed?
They fit the definition of that under the.
Were they sealed? So, they were not sealed.
I believe that they should have been.
I didn't think so.
Presumptive.
I don't remember seeing anything saying sealed. Anyway, you want to wrap up, counsel?
Yes, Your Honor. Judge Kiesel abused her discretion in failing to explain why the least restrictive means of ensuring his return, my client, Mr. Simpson's return, were a 3,300% increase in bail. Judge Kiesel relied on legally impermissible factors and a presumption of guilt by increasing the bail 3,300%, Your Honors. Finally, Mr. Simpson presents no risk of flight to avoid prosecution. Mr. Simpson has never warranted. Mr. Simpson has appeared on this matter with bail and with no bail imposed. Mr. Simpson would like to make bail, but he cannot. The amount has effectively ensured that his incarceration, that he will remain incarcerated prior to a trial that no one can schedule at this point, Your Honors.
I thought it
Thank you.
Okay.
Oh, did you have something? Okay. Thank you. Thank you both very much.
Thank you, Your Honor.
Next case is Powell versus the City of New York. I'm recused on that case. Justice Weber is vouched in. Please wait until I'm out of the Zoom before you begin. Thank you.
Thank you.
Thank you. We will now proceed. Counsel, my understanding is that you have reserved 5 minutes and 1 in rebuttal. Is that correct?
Yes, Your Honor, that's correct.
Please proceed.
Thank you. Good afternoon. Again, Lisa Como for the plaintiff appellant. I would really just like to emphasize, first, with respect to the Monell issue, that the reliance that the plaintiff is placing on the Poventude case, the federal case that's discussed at length in the briefs, we consider it very significant here because of the factors that were so similar and significant with respect to the ongoing policy, if you will, the policy that was found to present a colorable claim on a summary judgment motion in that Poventude case. And it's notable that even though the principal basis for the opposition from the city here has to do with the fact that the list of cases that's in the appendix to the proposed amended complaint were some older cases that were issued in alleged in support of the Poventude case. But there is an indication in that decision that discovery revealed that the very same policy of not disciplining officers for failing to turn over Brady material to the district attorney continued until 2011. And that also it was not until 2010 that any attempt was made by the police department to ascertain and to keep track of in any way the claims that had been filed involving that type of misconduct. So basically, what Poventude shows us is that between 1990 and 2011, there was this ongoing policy of not disciplining officers basically ever if the witness in the federal court case is correct and is to be believed, that no one was ever disciplined for this type of a Brady violation.
But that's not something that you alleged in any form in the original complaint, correct?
No, that's true, Your Honor. We're relying on our request to amend the complaint and on the proposed amended complaint. Because this motion was directed to the pleadings. It was, again, not summary judgment. This case had was ongoing for quite some time. There's been very little to no discovery that took place. So at the time the motion to dismiss on the pleading sufficiency was made, it hadn't progressed to any form of depositions and certain limited documentary discovery, which is not comprehensive at this point. But again, that being said, we emphasize that this is a pleading sufficiency issue. It's not a summary judgment issue, and we submit that plaintiff should be given the opportunity to develop the allegations as proposed, that the proposed amended complaint should be allowed, and that there's enough in the Poventude case to support this ongoing policy that continued to be in existence over a very long period of time. In addition, we asked the court to consider the DaCosta case. This is on the issue of the relation back doctrine. The DaCosta case from federal court, I believe, as far as I can see, it's an issue of first impression as far as considering whether the parties can be deemed united in interest based upon the city's obligation to indemnify.
Well, counsel, let me just take you back to the Poventude case. In this case, do you have anything, are there any factual, is there any factual support, like in the Poventude case, regarding your allegations? Any factual support whatsoever?
As far as the allegations, Your Honor, our allegations.
Yes, as far as the allegations. So my understanding was in that case, the plaintiff supported the claim by identifying the number of civil and criminal cases with the allegations in that particular case. So in this case, do you have any civil and criminal allegations which would support your allegations in this case?
Our position is that the very same conduct, the very same pattern was happening going back to at least 1990. In fact, probably going back before that, based on the cases that have been reported. But we rely on the same cases that Poventude relied upon, the fact that the policy remained in effect, according to the witness in that case, until 2011 at the very least. And again, that being the no disciplinary proceedings.
So ever. You can identify such a policy in this case?
Well, we haven't had any discovery, but our allegation is that Officer Gross was not disciplined either. That not only did he withhold the exculpatory nature of the video that he viewed prior to the plaintiff's arrest, but that it was also lost under mysterious circumstances. And we certainly cannot say, we can only allege at this point that he was not disciplined for that, but that's what we allege will be shown because it's the same time period that this policy has been ongoing.
But you don't have any good faith. Did you do any investigation? I mean, you can't just say it because you think later on it might turn out to be true. You have to have done some investigation and have some good faith basis in this case, not just a general view that nobody ever gets disciplined, but did you do any investigation of that in this case to even may have a good faith basis to say upon information and belief?
Well, yes, Your Honor. In fact, it was the federal court's finding that that up to 2011, no
I'm
one
not
had ever
talking about the federal court. I'm talking about you as the attorney for the moving party and the plaintiff. What investigation did you do? Because you've got to sign the pleading that said that you did an investigation. And so you're telling me your investigation is, I read that federal case?
Well, Your Honor, as appellate counsel, I can only truthfully tell you what I see in the record here. But I would submit that the plaintiff should be entitled to rely upon there were very contemporaneous findings. I mean, it's only the Poventude case is only a few years old, and there was a long history and extensive discovery in that case, and plaintiff seeks to make the same allegations and rely on the same proof. And the fact that some of those cases were a bit older, when you look at the very long-standing history of this policy that was ongoing, again, from 1990 and continued into the time period of this arrest, our argument would be that we should be entitled to rely on that, and that at the pleading stage, it shouldn't just be thrown out as a matter of law.
So your pleading would be based upon the federal case and based upon the investigation and the report rendered in the federal case. Therefore, that's enough to sustain your burden in order to proceed with discovery in this case, because it happened during that period of time. As per that case, that's enough for this case.
So, some of the audio cut out, but I think I heard your question. Basically, yes, that's the starting point, and it's reflective of a very long history of the exact same thing happening. And I think that's what's really even more important is the finding in the witness testimony that there is admissible proof from witnesses for the defendant themselves that this disciplinary or lack of disciplinary policy was ongoing at the very same time of this arrest. And
do you have
I would also
make any correlation between the loss of the tape in the videotape?
I'm sorry,
in this and Brady violation? Do you have to make any correlation between the loss of the tape in this case with those other Brady violations or the violence in the federal cases?
I'm sorry, again, part of that cut out technologically, but there's two aspects. It's not just the loss of the tape. It's first the failure to disclose the exculpatory nature of the tape, so that evidence was never, as far as we know, presented at the grand jury or anything like that. And then it's also the loss of it. I'm sorry, I'm not sure if that actually answers your question because I only heard sort of the second half of it.
It does. It does. You have time to rebuttal.
Thank you, Your Honor.
City?
Good afternoon, Your Honors. May it please the court, Alina Drucker on behalf of the city. So, ask you to affirm now and then dismissal of the Monell claim. The Povetid case that the plaintiff would like to rely on. I mean, what the plaintiff has done is just copy pasted the appendices that were attached to the complaint in the Povetid case into their complaint. That case involves a prosecution that occurred in 1997. This case involves an arrest from 2011. How I'm not sure I can follow how that can establish the existence of a municipal policy or practice that is actually relevant to the claims here. But even then, if putting that aside, there's no attempt to correlate a municipal policy or practice that allegedly existed in 1997, according to the Poviton case, to what happened in this case, which
well, that's your adversary's argument, is that further discovery is necessary to determine whether or not the policies and the practices were also occurring and whether they're relevant to what occurred in this case.
that is, but to plead a claim with sufficient particularity to survive a motion to dismiss, the plaintiff had to do a little more on a Monell claim, which is a claim that is based on the theory that there's a municipal policy or practice that is causally linked to a constitutional violation. What we have here in terms of allegations is that an officer had a videotape which he gave to an ADA, but then lost the original copy of, so that a subsequent ADA requested it and it was lost. And following that, the claim, the criminal case against that individual was dismissed on the prosecutor's memo. There's no connection with the legal theory of what happened to this plaintiff as a criminal defendant and a policy. We don't know whether there's no even real allegation that Detective Gross even did anything wrong, like in terms of, I mean, the allegation is that he intentionally lost this videotape that was potentially exculpatory, but there's no allegation too that is factually supported by anything, that a climate of lack of discipline in 1997 caused that. And that's what you need for a Monell claim, a causal link between a municipal policy or practice and a constitutional violation. And that's what the court below found, that this is just a copy paste. The original complaint that was filed was just boilerplate about claims with literally no factual allegations. If you struck the boilerplate description of the claims, there was nothing in the complaint. Like 5 years or so later, a year after they learned the Detective Gross's identity, which I mentioned for reference to the other argument, they file this attempted and amended complaint to further particularize, but the complaint is the same basic complaint. It's just legal allegations and stripped of all of those sort of legal statements and things copy pasted from other complaints and allegations about settled cases, which are themselves not evidence of anything. There's a whole list of cases that were settled cases from the 1990s that involved allegations in their complaints that may or may not have dealt with exculpatory evidence. I think of a survey of them, only a small fraction of them even had to do with exculpatory evidence being lost. There's just not enough there to support a claim to get
Counsel,
past the pleading threshold.
Could you comment on the proposed expansion of United in Interest? You're frozen. Oh dear.
I'm sorry, Your Honor. I can hear you, but I can't. You've gone blurry.
Okay. But you heard me. Yes, now I hear you.
I heard you, but then I lost you in the middle. Could I comment on? I'm so sorry.
On your adversary's proposed expansion of the term United in Interest.
Yes, Your Honor. It's actually not a question in the DeCosta case. It was 2017. This court has twice since reaffirmed the United in Interest standard that has existed under state law, which has police officers are not united in interest with the city. And that's for federal claims, and I can explain why that is and has always been the rule in New York. First, because the claims, for unity of interest, the claims have to rise and fall together. But for a federal claim, which is different than a state law, like a vicarious liability claim, under a federal Monell claim, the claim is against the city for a policy or practice. The claim against the individual is based on conduct that causes a constitutional violation.
And do you believe that there should be an expansion of the state?
I don't believe there should be I don't believe there should be an expansion because I think it is, I mean, the Court of Appeals has been pretty clear in the Bourbon case that that the United in Interest standard requires there to be the same defenses and the same claims, and the claims literally have to rise and fall together. What the plaintiff is arguing is basically that because corporation counsel often but not always represents officers, that should be enough, and the rest of the legal standards should be thrown out. But the officer has available to him, for example, qualified immunity as a defense. The city doesn't have that defense to the Monell claim. So the claims aren't the same, the defenses aren't
I'm sorry,
the same.
excuse me, counsel. Excuse me, counsel. Ms. Drucker, can you turn off your camera? Ms. Drucker?
Oh, yeah. Yes, Your Honor. How about now?
Thank
Any
you.
better?
Yeah, yes, thank you.
Oh, excellent. I'm sorry about that. Should I repeat myself?
No.
Yes, please.
Oh.
Oh, no.
You were off.
So,
Okay.
The united in interest standard under the Baron Court of Appeals case makes clear that the claims have to rise and fall together. The defenses need to be the same. So we're not talking about just a claim where two people are sometimes but not always represented by the same counsel, which is effectively what the federal court decision says. It says because of a combination of indemnification, which sometimes but not always is given to the officers, that you should just assume under state law that the state courts have been getting it wrong forever, and that actually officers in the city are united in interest. But even so,
And
first of all,
indemnification, right? Indemnification can be a contractual thing by people who have no common interest in any other context. Their defenses are different, and they just have a contract by one says, no matter what, I'll pay your fees. So if we adopted that rule, that would be quite a substantial expansion of united in interest.
That's right, Your Honor, and I appreciate you saying that because I was about to say something similar, which is
thank you. Do any of my colleagues, are there any other questions? Thank you, counsel.
Thank you, Your Honor.
Yes, Ms. Strucker, you represent, you have 1 minute in rebuttal.
Thank you, Your Honor. Just very quickly, given the limited time, I could only ask the court to consider the underlying rationale in the DaCosta decision. I don't want to belabor it. I understand the court's response to that. But I would just like to point out, going back to the Monell claim for just a moment, my understanding of the facts, and as alleged and as in the memorandum that gave rise to the dismissal of the charges, it's not that Detective Gross he claimed he gave the videotape to a district attorney. He couldn't identify that person. He was very vague, apparently. He said, I gave it to a DA with brown hair kind of thing. There's no evidence that he really ever turned it over. And again, it's not just the loss of the videotape, it's the concealment, if you will, of the contents of the tape, and that he clearly himself found it to be exculpatory prior to the plaintiff's arrest. And I do understand and acknowledge that the cases that are the underpinnings of the Poventude case are older cases. But again, it is the exact same policy. And I know I've already said that, so I don't want to repeat myself, but I think that really is the linchpin, and that's the key, that this has been an ongoing lack of disciplinary measures that was recognized in the federal court going back decades and continuing, according to the proof, through 2011 without any effort through that time, except to a beginning in 2010 to try to get sort of a handle on what the claims were that were being
alleged. Thank you, counsel. Your time is up. Do any of my colleagues have any additional questions? No.
Thank you very much.
That concludes the oral arguments for today. Court is adjourned. Thank you.
Thank you.